Ladies and gentlemen, good morning and welcome to our conference, Navigating Arbitration in the Digital Age, Cyber Resilience and Dispute Resolution. Whether you are here with us in person or joining online, we are delighted to have you with us. There are three reasons why this conference is a particularly special event. First, of course, because of the topic that is closely related to this year's problem of the Wismut. In our rapidly digitalizing world, cybersecurity is absolutely paramount, especially in arbitration with all the confidential and sensitive information involved in it. Second, it is because of our stellar panels of experts who bring a wealth of knowledge and experience to the table, and we are particularly thrilled to hear their perspectives and experiences. And third, it is because this conference opens and is part of the 15th edition of the Warsaw Pre-Moot. We hope that within the next 2 days, you will be able to gain, like in previous editions, valuable experience that you will be able to successfully use both in Vienna and in Hong Kong. Let me now take the opportunity to thank our our partners and sponsors. Let me start with the partners, with ICC Poland, Court of Arbitration at the Polish Chamber of Commerce, Court of Arbitration Leviathan, and the General Counsel to the Republic of Poland. I want to extend a special thanks to our sponsors, Clifford Chance, Wardeńskiej Wspólnicy, GP Partners, Olesińskiej Wspólnicy, and Jabłoński and Koźmiński. It is my great pleasure now to give the floor to the moderator of the first panel, to Adelina Prokop, who will introduce the speakers.
Thank you very much. Welcome, everyone. My name is Adelina Prokop. I'm the member of the Arbitral Council at the Court of Arbitration in the Polish Chamber of Commerce, and partners Clifford Chance. And I have the pleasure to be moderating the first panel today about the cybersecurity unveiled, a deep dive into the basics. And together with me, I have a distinguished panel of 4 experts whose bread and butter is cybersecurity. Starting with Jakub Barański on my right. Jakub is a partner at Wardeński and Wspólnicy law firm. Jakub handles primarily cross-border judicial and arbitration disputes, and he takes part in cybersecurity cases, both in civil and criminal cases involving phishing, business email compromise, fraud, and liability of online cryptocurrency exchanges. Is this a fair summary, Jakub?
Yes, that sort of collects it.
Very well. Further to my right, I have Michał Ćwiakowski. Michał is a partner at GP Partners law firm. He leads the financial sector team at GP Partners and co-leads the technology practice. Michał advises financial institutions on all aspects of their activities, including AML, payment services, banking regulations, and I believe has also quite a broad experience in cybersecurity.
Yes, I was worried for a while because I have not provided you with a description, but I see you've made your own research, so...
Absolutely. I hope it's a fair summary, yes. Then we have Wojciech Jarosiński, partner at Olesiński and Wspólnicy law firm. Wojciech leads a team specializing in advising on new technologies and resolving disputes concerning the implementation of technology projects. He supports clients at the project implementation stage, as well as in litigation and arbitration. Wojciech, if you have anything to add, please do it now.
Thank you for this introduction. There is one thing I have to add. I'm also alumni of this arbitration moot, and I cherish every moment of the entire process of getting to Vienna. Thank you.
And then, last but not least, Jan Rysiński, partner at Łaszczuk law firm. Jan heads the white-collar crime practice at Łaszczuk and Partners, and he's working on a number of complex domestic and cross-border criminal proceedings involving insider trading, money laundering, fraud, and corporate misconduct. Jan has successfully represented clients in cybercrime cases So we hope you will share some insight from that experience as well.
Thank you for such a warm welcome.
Good, so let's begin. Gentlemen, the last time I witnessed a cybersecurity scandal event was on the recent episode of Morning Show. Are there any Morning Show fans on the audience? So you should definitely watch Morning Show. It's a great TV show. In one of the episodes, it is focused on chaos that ensues after a cyber attack hits a fictitious large news network. The power is cut, broadcasting is cut, and the CEO of that network receives an email with some compromising confidential information gathered from private mailboxes of the main stars of this network, and hackers request staggering ransom of $50 million US dollars to be paid within 48 hours. So this is on the TV show, and my first question is this just a sensational portrayal of how cybersecurity incidents look like, or are real-world challenges similar to that what we have seen on Morning Show?
Oh, I think
Michał,
it's
do you want
yes, thank you. For a start, just to set up our discussion, I think we should start with, I would say, common definition of cybersecurity. And I would call cybersecurity, I wonder if you will agree with me, but it's like a state or an effort to get to the state where we are free of the threat of being subject to the any kind of the cyber threat. Mostly cybersecurity focuses on internal or external but malicious acts. However, I would say that cybersecurity, and that's what, in my opinion, current trends in regulation also show, is that it's not only about malicious acts, but it's also, in general, about the proper functioning of IT systems and providing services based on IT system. Anyway, we want to, by providing cybersecurity, we want to avoid incidents. And again, how would I define incident? Well, it's, on the one hand, it's the event that compromises confidentiality, integrity, and availability of the data. That's the first thing. And on the other hand, it's the event that might affect adversely the services that are provided by our IT systems. Usually, both happens together, and this is the case of I would like to present in the beginning of our presentation. Let's call it hypothetical, although it's not. However, due to confidentiality obligations, it had to be anonymized as much as possible. And this is the event that refers to the ransomware. This is a kind of attack, as I said, that usually entails both compromising the data, at least due to the loss of availability, but also usually confidentiality too. I will speak about it later. And affects and usually aims to affect also the services because, well, in general, ransomware attack is when the attackers, they encrypt some of the data processed by the attacked organization. And the encryption affects the operations. Usually the organization cannot perform its services, cannot continue its business, and thus is forced to pay the ransom to the attackers. Quite often, the attackers also extract some of the data, usually sensitive data. They threat they will publish the data, and in that way, it's aiming also to to have a bigger influence on the attacked organization to pay the ransom, simply pay the ransom. So that's more or less what happened here. We had a BPO organization. It was processing the data on behalf of its B2B clients. So we have a few actors here. We have this attacked BPO, which acted on the grounds of GDPR as data processor. We have controllers that entrusted processing of the data, the clients, and we have data subjects that are actually, I would call them hostages in this situation, because it's their data that has been extracted and that might be published. What else? I think that the vector of the attack, well, in this particular case, well, to be honest, it was not determined. It's not that important here too. The fact is that the ransomware was injected, the data was encrypted, and some of the personal sensitive data was extracted. Due to the encryption of the log files of the organization, it was impossible to perform the proper forensic analysis and to determine what actually happened, and also the scope of the data that was extracted. Obviously, the attackers demanded the ransom for refraining from publishing the sensitive data. It wasn't necessary for the organization to pay the ransom in order to decrypt the data, because the business continuity disaster recovery worked well, and all the data was restored from backups, no data loss, except of the log files from the security systems. And clients and data subjects were informed about the attack under the GDPR obligations. I made a graph related to the liability, who is liable to who. We will discuss it later. The line the arrow that leads from the attack company to attackers is, I would say, blurred. Maybe it's the right word. Well, the thing is that crime detection in such events is on a very, very low level. So actually all the actors and all the victims are left alone in here. It's all about liability between them. Usually we do not find the attackers. And one more remark before we move on. Prevention and due diligence, I know we'll discuss it later. Just wanted to mention it for the purpose of the discussion. The organization, briefly before the attack, was audited and was certified on ISO 27001, which is like, well, many doubt the value of the certificate these days. However, well, they passed the audit. They
before the attack, right?
Right before the attack.
Nevertheless, the attack happened.
Yes. I don't know if it brought the attackers, if they consider it a challenge.
Okay.
However, that's the fact of the case.
Okay, so quite a complex case study, a lot of stakeholders involved. We will have a deep dive into all those elements that you mentioned, so prevention, liability. But first of all, let me ask you this question. How often do such incidents, attacks occur in practice? Do you have any statistics that you could share with the audience, any data on that?
Luckily, I thought you might ask this question, so I prepared a few statistics.
How convenient.
Yes, always be prepared, right? So let me start with some global statistics. I found out most of them are for 2022 because not many summaries and reports available for the 2023 for now. And in accordance to the data I found, there is approximately 3.4 billion phishing attempts daily. Phishing attacks are the most common type of the attack, and they stand for 90% of all data breaches that happen. We were discussing ransomware. In accordance to the same reports I found, there is nearly 500 million ransomware attacks.
Globally.
Globally. I will get to the Polish data too, just in a minute. And average ransom demand is $7 million, which is quite a lot. And I think it also will be subject to our discussion. Nearly half of the organizations actually pay the ransom as the consequence of the attack. Also, the average cost of a data breach globally is $4.5 million. I also reached to FBI statistics for 2022. There were 300,000 victims of phishing attacks. And again, referring to the ransomware attacks, 2,400 victims of ransomware. I assume we are not discussing the data subjects in the individuals. That would be far too less. I assume this is 2,400 organizations that have been attacked by ransomware attack. Now, getting to Poland, I think the statistics are quite optimistic. I don't know if we are just not as wealthy and not that good target of the attacks. However, we look not bad in comparison to, quite well, I would say, in comparison to the United States. In accordance to CERT Polska statistics and the report for 2022, there was 40,000 incidents reporting to CERT. It is 34% more than in 2021, so we can see a significant increase. Most of which, again, was phishing incidents, but it's the same all over the world. By sector, the most incidents have been reported in energy, banking, and another financial sector infrastructure. I assume no surprise that the ransomware attacks are considered the most destructive, but only 85 incidents have been reported in 2022 in this area, which doesn't sound that bad as FBI statistics, for instance. And just to finish, Polish Data Protection Authority, in accordance to the Data Protection Authority statistics, 13,000 incidents have been reported, data breaches. Obviously, not all of them are the result of cybersecurity attacks, but all of them are the result of some kind of a breach of security in the area of data processing. And still, external breaches are considered one of the main cause of data breaches and severe and material incidents within cybersecurity. So I assume the things you heard in morning show are the real thing and the real deal, not just a kind of sketch.
Worrying. Jan, could you, based on your criminal expertise and experience in cybercrime cases, could you please perhaps describe a little bit more what are different types of cybersecurity breaches? And we've heard from Michał various types of attacks. What is your take on this?
Sure, thank you. If I can start by picking up on what Michał said about the statistics, I actually remember that one of the first cases of the cyber attack I was involved in, it was in 2014, and I also studied the FBA statistics at that time, which is interesting because I specifically remember that there was this part which was interesting for me the most. The case was about the so-called CEO fraud. And then the FBI statistics were that $2 billion in the period of 2 or 3 years, every period, are extorted from the companies just by the CEO fraud. And at that time when I saw it, I thought, okay, it's a lot, it's a massive amount of cases and money extorted from the companies, but this will decrease, obviously, because the business will get prepared. Everyone will become aware of such cases, and apparently it didn't happen at all. I think that the statistics show that after 10 years, we got around 1,000% increase in the value loss for the business because of such types of cases. So definitely the world is moving forward, and the cyber criminals are moving forward faster than the business and the authorities. And in this period of those 10 years in our practice, from the point of view of white-collar crime cases, we saw several trends of the breaches that were most popular in certain periods of time. And first one was the CEO fraud, which was super popular in the middle of between 2010 and 2020. There was a massive amount of such cases, and comparing to current times, you could say that those types of fraud were kind of romantic, because
and could you explain a little bit more
definitely.
what does CEO fraud mean?
Because they involved not only the breach of the IT system and the breach of communication between the parties, but they also involved the social engineering element, which was a key element to the fraud, because usually the fraudsters contacted the CEOs, hence the name of the name of the fraud, CEOs of the companies, and they encouraged them to make the fraudulent bank transfers, and together with the breach of IT communication, which was fairly simple because it involved simply change of the address of the sender of the email who sent the email. So it was something that everyone in this room could really do. They were able at that time to make those companies' representatives to make bank transfers on massive amounts of monies. But this changed. People became actually a bit more aware of that. So I believe that this kind of fraud became a little less popular nowadays. Then there was, we saw a trend in our cases where the very simple kind of fraud was very popular, which involved only simply preparing a false website of a bank. And you wouldn't believe how many very professional companies would fall for that, just simply by putting their banking details into a false website, and by that giving the fraudsters their banking details and passwords, enabling them to empty their bank account in minutes. And it sounds like a case for a you might think of an older people to fall from that, like individuals, but no, it did involve business very much, and it did hit hard in some period of time. And now I think in the recent 3 or 4 years, the most popular type of fraud that we see is something much more sophisticated, because it involves an actual breach into the communication between two business parties. So you would have two parties of the contract having a simple day-to-day business communication through email, and the fraudsters are able to hack to get into this communication, and the fraudsters are able to impersonate one of the parties to the contract, and this is something that it's really difficult to find out when you see it at some point, because the communication looks exactly the same as it was, but at some point there shows an email. Okay, now we have to change our bank account, so please now make the transfers from this contract to this new bank account. And this really happens, and the cases which we observe are very popular, if that's the correct word to describe it. But it's also extremely difficult for companies, because it may cost a lot, really, just by simple falling for that pretty simple but extremely effective fraud. So that would be the trends that I observe in the last years in those kind of cases.
Thank you, very interesting. So we know that the cyber security attacks, threats are becoming more and more popular, prevalent, and they are becoming more and more sophisticated. So the first question that comes to my mind is, what can we do to prevent this? What can we do to avoid cybersecurity incidents? Wojtek, would you like to?
Wanted to make one remark.
Certainly, go ahead, Michał.
Yeah, because Jan said that the attacks are becoming more and more sophisticated. Generally, I agree with you. There are new methods. I run out of hard data, but I can tell that when I was going through statistics, still the most of attacks, they rely and are based on the most easy and the easiest are based on the easiest methods.
Which is?
Which is like a simple phishing, you know. It's like Jan said. It's like some of the attackers, they interfere into the communications, etc. Obviously, I agree. We have a spear phishing, which is targeted for the specific organization. However, the most breaches and the most frauds are based on the very simple methods, phishing again, and it is because cyber criminals are just like any other business. They use as most effective and cost-efficient methods as possible. If you can do something simple, just do it simple. And that's it.
Yeah, thank you for that. I agree completely. And you cannot stress out how simple those methods in the nutshell are, because they rely so much on the fact that you have to make somebody believe that you are who you are. And you don't really need the sophisticated IT tools or whatever. It's just the kind of talent, right? It can be supported by hacking attack, but you can have millions of euros transferred just by a CEO believing that somebody who's calling him is his superior.
So if the methods are
You guys heard me, right?
I heard, yes. In a nutshell, simple method and can bring you huge results, right?
Yeah, but it's easy to prove, because Jan mentioned the bank account frauds, and I would say every security system can be broken. This is what is said. However, nobody is trying to breach directly the banking systems. They prefer to breach the procedures and rules of the given organization on the other side.
But the question that is bothering me, so if these are that simple methods, can you equally, in a simple manner, avoid such threats? Can you just, educate your employees, don't click on any, fishy emails or suspicious emails? Wojtek, what's your perspective? What can we do to avoid cyber attacks?
Thank you.
And turn on your microphone to make
Thank
sure that
you.
our online audience could hear us.
Thank you for your question. I will start with a question to the audience. Do you remember the movie To Kill the Mockingbird? Have anybody seen that movie? That's like 60s, I believe, based on a novel, one person.
They're not watching TV. They haven't seen morning shows, so.
Must be on streaming platforms, at least one of them. There is a scene where a movie is about a lawyer who defends a tough case, and he walks back from the courthouse to his office, and he thinks about the case. Just walks, enjoys the sunshine, and thinks about his case. When he comes to his office, he reviews the papers that he received by mail, not email, mail, and his assistant tells him what kind of calls were placed to the office and who was trying to contact him. And if you want to avoid cyber attacks, you would have to get to that stage, return to that stage of just paper and no notifications, no phones. Who of you have a phone today with you? Not everybody. How is that possible? Who of you guys is using either iCloud, Google Drive, or Microsoft 365 Plus? Everybody. I saw a gentleman over there taking photos with his iPhone of some files.
Delete them.
No, don't. Send to everybody. AirDrop them. I saw a lady over there recording us. And what's the name of the claimant in your Wismut case? Oh, yeah, say that again, please. SensorX. SensorX. It's so cool, isn't it, when you write a motion related to SensorX and it magically appears across all your devices, isn't it? It's so great that you can ask the chat GPT to write half of your motion, isn't it? You don't do that?
You can't.
You can't.
AI statement rules.
That's great. it's impossible right now to avoid cyber attacks. It's the same impossible like if you walk down the street, even in Warsaw, at some point someone will try to mug you. Just statistics. And when you try to interact with the world in modern ways, you will feel what the world is. And what to do to avoid it? I'm always so tempted.
If you can, at all.
I'm always so tempted to press those great offers that come to my email related to the lunch menu in the nearby restaurants. You know, that's one of the angles of attack. To figure out what's the nearby restaurant and send to the employees of the targeted company lunch offers. And when you click a link or download PDF with a special QR code, with a special discount, 10% discount, it's always a bargain, right? Your device gets infected and you're then vulnerable. And my clients, they tend to undertake two kinds of activities to avoid cyber attacks long term. First, simple one. They hire a consulting company. They make a project about that, and that consulting company, it tests their devices, different devices. The infrastructure starting from like the very bottom, going through servers, through middleware, to operating systems, software that runs in the cloud, software that helps them communicate, the handheld devices. And those companies, they present a list of vulnerabilities and ways to prevent those vulnerabilities from being exploited by potential hackers. And what do lawyers do with that? Lawyers take contracts with vendors who provide IT solutions, infrastructure or software, and they try to enforce upgrades. Usually vendors are very happy because they say, oh, that's something new, that's CR, change requests, we need some money. And what we try to do, we try to tell them, no, that's your fault, that there is this vulnerability exists and you have to actually fix the problem or we'll charge you with contractual penalties. And that goes on. And of course, once the project is complete, recommendations are likely obsolete. Because the technology advances so quickly that you just cannot keep up with it. And these kind of projects, they do not resolve another major issue, for instance, me being hungry during the lunch hour and my willingness to go for that great deal, 10% discount on the nearby lunch place. And I have some clients who are cyber aware to the point where often one board member, just one, approaches a law firm and an IT specialist and tells that nobody knows about this project in the firm. And we want you to help the IT team, the IT company, orchestrate attacks from different angles on the company. And those angles include both software and protein-based attacks, meaning challenging humans and their weaknesses. Because what's the weakest part is always a human. The human makes mistakes. The human is so willing to go for that lunch discount or pick up a pen drive lying for free somewhere in his office and stick it to your computer, let's see what's inside, that the human will always be the weakest point of any cyber security issues. So there is no one simple solution, not one pill. It's not like you hire a vendor and responsible for ensuring your protection. Just outsourcing risk, it doesn't mean you will not be cyber attacked or you will be able to defend your company from cyber attacks. It's just shifting the risk. Somebody else will be responsible for that risk, and if they have good lawyers, they will tell you that your humans within your organizations were weak. Batteries, right? Protein-based batteries, or how was it in Matrix? And you have to train. And you can actually start training with SensorX. When you're working with SensorX, why don't you start thinking about it? I'm not asking you to read through terms and conditions of your iCloud service or Microsoft 365 services to check where the servers are located and what kind of layer of security they offer. But you can try to think whether, for instance, you drop the name of your client in this vSmooth tournament on Messenger, on WhatsApp, on different channels of communication, or do you try to somehow address the risks involved with modern ways of communicating? Start today. Practice makes perfect. Thank you.
Perfect. Thank you for this practical insight. I have a question to Jakub. We've heard what you can practically do to at least try to avoid cybersecurity incidents. Can you walk us through any, perhaps there are broader regulations that come into play on this front?
I thought you were going to ask me what you can theoretically do practically. I think we fulfilled our promise of the panel's topic of a cybersecurity deep dive. We've heard very in-depth statistics from Michał. We've heard very in-depth information on the types of cybersecurity incidents from Jan and on what you can do from Wojciech. But I think it would help both us as the panelists in our future discussion and the audience to take a step back and sort of take a wider lens view of the topic. And I think there's three trends, general trends that you should keep in mind regarding cybersecurity. They're both trends of what is happening from the, let's say, malicious actor side of things, and they have an equal response from the side of the regulators. Now, the first trend, I don't think we really covered it all that much, but what you can see currently is in this situation where cyber attacks are becoming easier to conduct because there's cyber hackers that publish these exploit kits, which are basically ready-made sets of, let's say, technology that you can use without a lot of skill to implement, for example, a ransomware attack. You've even got groups that conduct attacks as a service, ransomware as a service groups. And what that causes, and this is the trend I think you should really keep in mind, is that it makes it economically more feasible to attack even smaller businesses. And that's something that we're seeing also in Poland. More and more often, it's not just the big entities that will potentially offer a high-level payout. It's more and more common that smaller, medium or small-sized businesses are falling victims to quite severe attacks. For example, there's been at least 2 incidents from the top of my head in the last year or 2, which involved tax advisors or HR companies. And this is a trend that's being seen by the regulators because, for example, the European Union is absolutely one of the primary, let's say, issuers of regulations in every area, but especially in cybersecurity. We have the Digital Operation Resilience Act, which sort of deals with financial services companies. We have the NIS directive, the first version, the second version. We have a lot of regulation, and what they're all have in common in respect to this particular threat is that they see that you also need to help those smaller businesses. And how they do that is they require the larger businesses, the operators of essential services, the financial sector companies, to sort of expand this umbrella of cybersecurity. They are basically required by the regulations to provide third-party security. So they need to make sure that, for example, their tax advisor is to some extent, to the extent of the applicable level of risk, also compliant with certain standards. So that's one theme or topic. The second theme we've touched in more detail, that it's not really about very advanced technical issues. Social engineering is the method of choice for all attacks, and it's not the case that, for example, bank account frauds use simple methods and other types of attacks don't. No, even in ransomware, I encourage you to look for there's this firm called Coveware. They publish quarterly statistics specifically on ransomware. And from their statistics, you can see that email phishing, so a very simple issue, is the primary attack vector, so the way that you begin or initiate a ransomware attack. And this is something that you need to handle in the regulations as well. And how it is handled is by forcing companies, businesses, or actually public administration bodies as well, to consider cybersecurity as a business risk, not just a technical issue that should be handled by the IT department or by the chief information security officer. No, it needs to be handled on management board level. Why? Because it's the management that will be able to ensure, that's the idea at least, a fair balance between a cyber hygiene policy, that's what you would call something that basically tells your employees not to pick up a USB stick that you found on the street and plug it into your office computer or open a suspicious attachment. But you need to have the management involved so that they can tailor this policy in a way that will, on the one hand, be secure, but on the other, it won't stop the entire business from running efficiently. And the final trend is that you can't really prepare entirely.
You can or cannot?
Cannot, it cannot. It's impossible, like Wojciech said. But that's also something that's being seen by the regulator. It's not being left to sort of hope and thoughts and prayers. Because there's this, and it's, I think, the most important trend. It's a focus on resilience, like in the topic of our entire event, rather than just security. So various procedures, regulations, they make sure that organizations are not just able to prevent attacks from happening, they also need to have procedures, assets in place that will help them survive an attack that occurs.
Let's follow up on that point, because what I'm hearing from you, all of you, is that, as you have just said, Jakub, you cannot really avoid a cyber attack. So what a company should do when the cyber attack actually happens? And let's start with this, the most imminent question. Hackers ask the CEO for a ransom, staggering 50 billion, like in Morning Show. What do? Do you pay?
Never.
No, you shouldn't pay.
Never.
But your confidential data is at risk. Isn't it?
Nobody opposes me, so I assume everybody agrees.
Sure, you have to pay, of course. I mean, you have to make the evaluation. That's what I would say.
Evaluation of what? Of the amount of the ransom, or the risk of the data being disclosed?
I mean, it's thankfully this kind of discussion is way more simple than the ransom discussions we see in media where a human being is involved. Here it's just data, right? It's money, it's nothing. So you just have to look on one hand, what's the ransom, and on the second hand, what's the value of possible losses that you would suffer. That would be my approach. I wonder what's the counter argument coming from you about not paying. I guess I can imagine some thesis you will have, but like I think it's just math. You open Excel and you decide what to do.
Well, there's a simple response to that. I mean, there is, of course, my primary motivation is less technical, mathematical, or statistical. It's more of a principle-based one, obviously. Of course, you don't pay because otherwise you encourage the entire system to develop, to work. If you don't pay, then the hackers will eventually have to change their modus operandi. But there is, I think, a more concrete argument other than, which I think is the most important argument, the common good. But if you want to look at it from an individual perspective, okay, you can calculate how much money they want. Maybe you can estimate how much you can get the hackers to go down on their initial offer. Maybe you can estimate to a reasonable degree the losses you would suffer if you didn't comply, and they would fulfill their threats of publishing the data or never unencrypting them. But how do you quantify the possibility, or for that matter, how do you try to protect yourself, secure yourself against the probability that even though you will pay, they won't comply with their promise, that the hackers will basically double dip. They'll ask you to pay, I don't know, which is something that happens. You have these attacks called double extortion. So they first come and encrypt your data, and they want a ransom for decrypting it. But even if you comply, they can come back and say, well, we still have it on our hard drive or somewhere in the cloud. Now pay us an extra, because otherwise we'll publish it. And even going further, how do you know that if they have received the payment for not publishing, what is there to stop them from publishing it anyhow? There's not a lot of statistics on this, as far as I know, but I've seen some, for example, from Sophos that says, on a very limited pool of surveyed businesses that I can concede, but it says that about 8% of companies that paid the ransom have basically found themselves in the comfortable situation where nothing happened. The hackers comply.
Nothing. So 90%, in 90% of
Yes.
cases, there were
They've been
further
duped.
attacks or further
Exactly.
discloses. Wow.
I believe there's another approach. I generally agree with both of you. And the obvious lawyer's answer would be, it depends. It depends what are your risks as a company. And the first thing that I would think about is, can we operate at all? Because I can easily imagine that we can find ourselves in a situation that it's our only way of having a chance to move forward is to pay. But what we definitely should do is to make everybody around believe that we didn't pay. So that we don't talk to the fraudsters, that we don't pay the ransom, but what we actually do is a whole other thing.
And what about the regulator's perspective? Michał, go ahead if you want to comment on that.
Well, I'm more with this part of
Which
the
is
table, to
pay,
be honest, which is
rather than not pay. Okay.
always depends. Obviously, always depends. But I agree with my colleagues on my right side. Well, definitely, it's just a matter of calculation. I think you called it public good, right?
Common good, yeah.
Yeah, common good. Well, I agree you've spoken like an authority or the law enforcement. Well, I agree it's in the interest of the society to, you know, if there is no one willing to pay the ransom at some point, the attacks would just simply disappear. As we said before, cyber criminals operates like any other business. Referring to what Jakub, you said that you have no guarantee. Absolutely yes, but we also have to remember that these cyber criminals at some point they also have to take care of their clients if they're not reliable, if the paying ransom does not help. Then again they, I would say, spoil the market maybe. It's the case, and what Wojciech and Jan said, I fully agree with that. Well, sometimes the paying the ransom or not and obtaining the decryption of the data is just a matter of surviving or not. There was ransomware attacks can be as destructive as we can imagine, and it really sometimes it is a matter of surviving and continuing the business or just the end of organization. It might happen. The ransomware attack might end up in, and I assume that many organizations that decide to, I think that I've seen the statistics that the main drive of the decision to pay the ransom is actually the decryption of the data necessary due to lack of the possibility to restore the data from the backups. And the main drive to pay the ransom is actually to restore the business operations, not to prevent the criminals from publishing the data. It's another thing, yeah.
If I may respond shortly, I can see some reason in considering payment. I'm not a moral absolutist. I, for example, see very good reasons to at least negotiate, because, for example, you can buy some time by entering negotiations. Secondly, you can maybe use them sometimes to obtain some additional information, because usually you're operating in the dark. You don't know what exactly they might have. And you might use negotiations to, for example, ask for a sample of what the hackers managed to take over. But even in a situation where it's the issue of restoring operation, where it's less about the threat of having our data published, more about the fact that we don't have backups, which is becoming pretty rare, I guess. That's why the business model is evolving more towards publishing information rather than just encrypting it. But even in that situation, you're still, even if you're back against the wall and you know you won't be able to operate, well, you basically need to start from scratch, you're still just hoping for luck and the goodwill of a criminal. It's still the case that you don't know if after you've paid, they will decrypt the data. Granted, I agree that the criminals do have, to a certain extent, an interest in not spoiling the market. That's true. But it's still a situation where you're in a very bad spot because you don't have a backup, and you could find yourself in an even worse one. And we're leaving aside the whole even wider, let's say, public policy issue here, because often, I think we'll speak later maybe about attacks that happened on the legal industry. But there were some recent cases where the group responsible for the attack on a couple of law firms was is known to be connected with the Russian government. And in such a situation, firstly, coming back again to the common good, we're giving money to an organization that will probably use it to fund a war or maybe terrorist activity somewhere. But we also touch on the possible compliance issue, because what about sanctions? We're giving money to someone that we know, because usually hackers will somehow tell you which group they're from. They're not going to tell you their identity, but you'll know it's, for example, Logbit. And what about sanctions then?
What are the regulators' approach? What is the regulators' approach to paying ransom? Have you heard about any opinions and actions they could take in that respect?
I would say close to what Jakub is saying.
So
do not pay. Yeah,
not pay.
obviously it is in the interest of the authorities, but still, it's in general it's not penalized to pay the ransom. This is the very individual case. I agree that the entity that is to receive the ransom might be sanctioned, but usually they use the channels that are, I would say, outside of the. There's not too many institutions up there that would prevent such transfer, cryptocurrencies, etc. But, agreed to this, but still, it's not penalized to pay the ransom. I consider it a business decision.
Wojtek, one last argument before we ask our audience to vote on that.
Would you mind if I split my argument into 3 points?
Go ahead.
Okay, so first, I will be really careful with the case about the penalty. It may be criminalized depending on the circumstances to pay the ransom, especially if you're paying to Russian hackers or to certain individuals who call themselves freedom fighters and by the Western world are labeled differently. It may be subject to criminal prosecution or in Poland or in the US, depending where, for instance, your headquarters is based or where your data is a complex nightmare of who has jurisdiction and who will be held responsible. I believe the example may not be very fortunate because it involves human life, but in case of Mr. Foley, who was unfortunately killed by ISIS a couple of years ago, his family could not pay the ransom because that would be under federal criminal law. But double check me on that. So I would make sure that the applicable laws, which are not obvious, do not criminalize paying the ransom. Second, check your insurance and engage your insurer. Maybe he can or she, maybe they can pay the ransom. And third, what you said, Jakub, about proof of life, the testing of the content of database. I was once handling a case where a part of database was stolen from servers of my clients. It was not locked, so you didn't have access. It was stolen. And the proof of its authenticity was presented to my client in dark web. We downloaded it, reviewed, and the first outcome of that review was that it's old database, so not much value in it. So the negotiations started to appear in a brighter light because we had lever. And second, from the scope and the time period of the data contained in the database, we're able to pin down people who could have possible access. And upon contacting them, the threats, they somehow disappeared.
Okay, so let's ask our audience, how many of you think a company should never pay a ransom? Please raise your hand. 1, 2, 3, 5, yeah. And okay, and how many of you think that actually, depending on the circumstances, sometimes paying ransom might be justified to avoid a bigger risk or bigger damage? Your moral arguments did not convince our audience, unfortunately. Okay, so, but we chose not to pay the ransom in our hypothetical scenario, and data was leaked.
Then we're in trouble.
We are in trouble. What happens next? So we have been attacked by hackers. They asked us to pay ransom. We refused, and then the confidential data is leaked. There is a breach. Our systems are encrypted. What do you do next? What are the immediate steps that you take as a company manager or as lawyers advising such company? Michał or Jakub, whoever wants to start.
You can start, come on.
Okay, usually what I advise, which is maybe not necessarily the number one thing you should do, but at least number two, in my opinion, is to initiate what you call in the cybersecurity experts lingo a forensic audit. So basically, engage a specialist, either in-house or external, to find out what happened. Because this is your number one problem at the start. You have some inkling that something is wrong because the employees have come to the office and they're not able to open up their computers, but you don't know exactly what happened. And by exactly, and this is the thing that you should try to, as fast as possible, find out is, A, what was technically the source of you not being able to operate, and secondly, what sort of assets was it? Is it money, or is it some type of data? And if some type of data, then what data exactly has been affected? And I would usually consider hiring an external expert because Michał mentioned at the very start about the CIA triad. It's this concept in cybersecurity of the three most important issues you need to take care of to consider yourself cybersecure. So CIA, confidentiality, integrity, and availability of data. And the issue with internal IT staff is that they're very much interested in the availability of data. That's what they're paid for. They're paid for making sure that everybody in the company is can use the IT infrastructure to work. So they're going to be 100% committed to making the systems running again. But they won't care and even a little bit about a possible leak and possible other risks. So the risks to integrity, something being changed in your systems, and as I mentioned, confidentiality. So maybe something being leaked or potentially becoming leaked in the future. So that's something that I would start with.
Mm-hmm. So hire external expert.
And basically ask them to do an inventory. That's something that you should end up with. You should end up with an inventory of what happened and what kind of assets, whatever they are, might have been affected.
Jan, and do you have any other suggestions?
Having a background in fraud cases, the first thing I would advise is to check your bank account, because you wouldn't believe how little the companies can know about transfers that can be made during the security breach. So the absolute key thing is to get hold of those funds, if possible, in the bank of the recipient. So the first thing would be to check if anything suspicious has happened on your bank account, and if it did, then you should approach your bank immediately. So it would enable your bank to contact the recipient's bank to try to get hold of these funds and freeze them, because otherwise you can probably say goodbye to them. At the same time, I would also Obviously, if it's a financial fraud, I would also advise to contact the prosecutor, because it's the prosecutor who actually can formally freeze the account for purpose of the future criminal case. But the first thing would be your own bank and possibly the bank of the recipient if you get the money extorted.
Okay, that's sensible. Michał, any other steps?
Well, I would say, obviously, technical measures are key here. You need to restore your operations, you need to restore your data. That is true, but I will also add the point, which is contact the lawyer, either internal or external. The security event is also kind of a regulatory event. There is a lot to do. I would refer to GDPR for a start and the obligations that almost every organization has under GDPR. And, well, in my view, engaging the lawyers as fast as possible is crucial. To back what I say now, well, a couple of months ago, I was doing a research for some other conference, or yeah, it was a conference, and I ran into the document prepared by the Cybersecurity and Infrastructure Security Agency. It's an American organization. There was like a literally two-pager describing initial response plan that every organization should have, and then one of the first points in this guidelines was review the plan with your lawyers, because they may have their own opinion, and they usually have their own opinion on how to engage the victims, how to engage the contractors, how to engage authorities and law enforcement. And that's what I would recommend. Like, being more specific, if you have a look into GDPR, we have a security incident, such as we made a leitmotif in the beginning of our discussion, the ransomware attack. Let's say data was encrypted, and then owing to the backup policy, well implemented, we managed to restore all the data. There is no data loss. The question is whether we had a data breach in terms of compromising the availability, as the lack of availability was only temporary, or whether there was not. Who will assess it? This is lawyers. Then we need to assess the risk and decide whether we engage in the contact with data subjects, what we say them, what we tell to them, or whether we also contact the authorities. And again, what is the content? What will be the content of the communication?
And on that front, would you recommend contacting the data subjects? Is it mandatory? Are we supposed to inform the subjects of the data that their data was compromised?
Well, it is mandatory depending on the risk assessment and how severe is the threat to the rights and freedoms of data subjects. So it obviously depends on the context of the event. It depends on the data and set of the data that was leaked, and also who came into the possession of the data. So it might be mandatory. In some cases, it might be a good practice or a good decision to contact. But basing on some of the cases I was dealing with in my practice, I would say, if you're not sure, think twice before you inform about something.
That might be prudent. So we've suffered a cyber attack. We took all these imminent acts and steps. We informed the regulator, we contacted the prosecutor, we checked our bank account. Now, the next question that the company may face is who suffered damage and whom we should chase, or is there any way to, for example, recover this ransom that was paid, or any way to seek damages from somebody who took part in this attack or who enabled this attack? I know this is quite a complex scenario, and there are various possible damages. But Wojtek, could you give us an overview of who can suffer harm, damage, and who is to blame in such cyber attacks?
Of course, thank you. Thank you for this question. I think that's one of the most difficult questions of this panel. On the level
That's why it went to you.
who can suffer damages, and I'm not trying to be philosophical here, but still pragmatic. It's easier answer, who can you go after, because there is so few people you can go after actually in this virtual world. But in terms of who suffered, it depends what was the subject of attack. If we think about popular election and the votes being counted on like machines like in the United States, who suffers from an attack or an attack on cyber attack on society if there is a bunch of fake accounts on social media spreading unverified information? We suffer, right? Democracy suffers, rights suffer, law suffers. And I mean, it's such a difficult question. On the other hand, if somebody just steals your information from your phone with photos of your cat eating an apple, does that really hurt? So that just really depends on the data that was stolen, the information that was misappropriated, and what basically was the target of the attack, whether it disturbs markets or disturbs one company or disturbs just you personally. It's easier to tell who to go after, because usually there's not much you can do. If cyber threat is executed by a professional, usually you don't have a big claim against that person because it's difficult to identify that person, and our legal system is unable to do much if you cannot identify the other party. But you can always check where you are with the stack, the technology stack that was subject to the attack. And even though I said at the beginning it's magical, like everything appears in the devices, across devices, right, with all those new fancy things, it's just still a bit of silicon, some copper, and it's located somewhere. It's as simple as that, right? It's just still at the end with addition of some silicon and wiring and some coding. It's physical. Like cloud, all those fancy new words, it's physical at the end of the day. It has to be plugged to electricity. It doesn't run on magic, right? It's electricity and it's real. So if you remember Mission Impossible, the movie, the first installment, the first part, there's this guy, was Ethan Hunt, I believe. Yeah. What's the name of the actor? Tom Cruise. Tom Cruise? Tom Cruise. Tom Cruise drops in the line to a secure vault, right? And he like hangs like a spider because he doesn't want to touch the ground. It'll like do something, fry him or whatever. And then he connects to a computer. So he actually accessed a physical server. And that's the very beginning. These days, those servers are often spread. It's not like one information, the photo of your cat eating an apple. It's not located in one physical location. It's probably spread across multiple server rooms for redundancy, for ease of access, and for security. But at the end of the day, that's some server. If that's your in-house server, then you have to ask yourself a question whether I have to fire my IT guy or not. If you outsourced, you should verify your contract if the attack came through servers, whether they were secure. The same applies to your middleware, to your operating software. You check whether that's something that you developed internally or you outsourced, and you check your contract and you claim damages. If possible, you have to verify the contract, whether it's possible to claim these damages, and you just build on top of that technology stack and check where the attack happened. But how to quantify certain damages and how to undo harm that was done, sometimes I have no answer to that question.
So let's start with the easier question that you mentioned. So who to go after? Whom you can claim? Let's imagine that data subject suffered some damage that you can be easily materialized and quantified. Their financial accounts have been accessed to, money was
who's stolen those data subjects file claims against you as the company, and now the question is whether the company can go after somebody who took part in this attack or whose systems failed, although they were supposed to protect us. Jakub, do you have any views on that?
Yes, well, if you followed my advice from our earlier question and you've
done the forensic audit.
Exactly.
Paying attention.
If you have a forensic audit and it at least gives you some initial inkling as to how and what might have happened, it's an easier question to answer. Because, well, put in simple terms, it depends on what has happened in the sense why we were vulnerable. And we can be vulnerable because, as we've discussed numerous times, because an employee was not careful enough, because somebody opened an attachment to a weird email, and that led to the hackers being able to install malware that sort of precipitated the entire attack, was able to see what's happening in our system and so on. But there might also be, and then it's kind of a question, do you want to sue your employee for the total amount of damages that you suffered as a company? I don't think so. There's also been, long ago, there was a case where an employer did try to sort of move the entire risk of an incident to an employee. But that case was lost. I think it was in Scotland. You can try to look it up. And since then, it was ages ago, and nobody is thinking about this seriously. But you could have a situation where the issue is with some sort of software or hardware that you have. There was a number of attacks 2 or 3 years ago, including Polish entities, suffered because companies were using a VPN, a commercial VPN for businesses, for enterprise use, which had something that's called a zero-day exploit, which is a very complicated way of saying that the software itself had a vulnerability that could be exploited, about which the producer of that software had no idea. So he couldn't patch it. So even if you, as a user of that VPN software, had everything updated regularly, you had an antivirus software with an updated library of malicious software, you still weren't able to be protected against it. And that's the question whether you can go against a provider of software in this particular instance. Because, well, for example, there's an issue of foreseeability or of the remoteness of the loss. Whether the provider of that software has, how far his duty of care goes. Because you can get regular updates from him, and those updates cover certain issues, but he can't foresee everything. That's the argument you would hear, because there were attempts against that particular VPN service provider to claim damages from him. And the issue is that you don't have yet a sort of general standard of cybersecurity. That's, I think, a problem, because unless you have a specific warranty from that provider in your terms of use, the claim is going to be difficult. And I can assure you that there's going to be a warranty only against reasonably expected vulnerabilities in the system. Now, there is a regulation on the horizon, a European one called Cyber Resilience Act, which is basically going to the idea is that it will set up a general standard for providers of any type of products with digital content, which means software, which is in itself digital content, but also any type of hardware, from a washing machine to a train that relies on software to operate. And maybe when we have that standard, because basically the regulation will require that if you provide something with a digital component, you need to make it secure by design to a certain specific level, then maybe those claims will become easier. Of course, you're going to face issues such as exclusions of liability in your terms of use, but that's, I think, something that you can try to negotiate. And I think this is going to be important because, like I said at the start, it's becoming more and more common for smaller businesses to face this risk. And they're not going to be able to ensure very extensive internal procedures to secure themselves before cyber attacks. What they can do is try to buy software from a reputable provider and hope that it's going to be enough to secure them if they use it appropriately. And I think that if the more we have opportunities to sort of enforce via sort of private enforcement on software providers to make their software secure, the bigger the chances those medium and small businesses have to be protected against data breaches.
And what about insurance? Can you take out insurance and then claim compensation of damages from your insurer? Have you heard any practices in this sector?
You can try.
Jakub, if I may, did I understand you correctly that your last statement, that the smaller the business is, the less likely it will be able to protect itself using outsourcing model, basically taking international vendors?
No, the other way around. The less likely it is that it will be able to put up the money to set up internally an extensive cybersecurity policy, procedures, and so on. They just can't rely exactly on what you said, external providers being secure.
Yeah, I found it in my practice that with cloud services, actually the level of security is raising among many firms because you're delivering standardized product, which is often on a way more secure level than, for instance, a law firm could be able to buy for itself.
Any other observations from the panel around damages and seeking redress?
Well, I've only went through the regulation you mentioned briefly, the CRA. I was wondering whether it has any provisions related to the limitations of liability. Well, they don't.
No.
Yeah, I made the fast Ctrl + F.
No.
Haven't found before. Yeah, because I would say this is the one of the primary defense that is applied by the producers of software, for instance. They might commit that the software will be secure. They might commit to within the maintenance services. They will provide patches that they will liquidate vulnerabilities, etc. However, at the end of the day, they imply standard limitation of liability, and I think that would be something that would actually change the market.
But I think that's my individual concept. It's not something that's widely discussed, I think, in the context of this regulation. But I think, in a way, it might help with these limitation clauses, because if you have a very detailed standard of security enforced by a regulator, and there's going to be an entirely separate certification process which we'll have to undergo to put on the European market this digital these digital products. And the more detailed the standard you have written down somewhere, the easier it might be to prove that there has been some form of exclusion to this liability limitation, that there was gross negligence, basically, on part of the provider of the service or the product, software product, that was somehow at fault. It might be, might not be, but it's something that might develop in court practice. We'll see.
Agree, and there also is a public law leg where there is a risk of administrative fines, etc. As you said, certified, you can be deprived of the certificate. That could work too. Yes, I agree.
And class actions, potentially. Claims from the consumers whose data was compromised, right?
Agreed.
Okay, so so far we've been talking about cyber attacks in the business industry, how CEOs of the companies should immediately contact lawyers to help them solve the problem. But what if the lawyers or the law firm is subject of the attack? Let's spend the remaining 15 minutes on that topic. And let's first of all discuss, do cyber security risks also arise in our profession?
Well, I'll go ahead because I sort of hinted that this is also an issue sometime earlier. there's been, everybody here must be aware that there's been a number of cyber attacks over the last years against law firms, also in Poland. I think the most recent one was the Allen and Overy case, which was in November last year, so pretty recent. And that was actually a ransomware incident. The public knew about it mostly from a very limited press release from Allen and Overy, but also from the fact that when you have these groups that conduct these ransomware attacks, they always have this thing called the shaming site, where you can, there's this big timer saying that in 14 or X days, data of this particular company will be published, and that's something that the press caught on to very quickly. We don't know, there's no publicly available information about how exactly that happened, that Allen and Overy has fallen victim to this attack. It's pretty well known why, what was the motivation, because it was just after, I think, shortly after it was made public that they have the intention to merge with Sherman Sterling. And actually numerous law enforcement agencies and regulators point that the risk of attacks is higher in these sort of financially important events in the life of a company. And I think the only other relatively well-known fact about the attack is that most likely Allen Overy paid the ransom. And the reason why we know it is that according to the shaming website, everything was going to be published that was stolen from Allen and Overy on the 28th, I think, of November. But and again, the press found out that the whole sort of tab with Allen and Overy on that particular group's website vanished much earlier, which suggests that there was a decision made to pay the ransom. So yes, law firms are definitely at risk. But I think there's also something that people lose track of, that also arbitral institutions are at risk. There was at least one incident involving a hack against the institution itself, rather than the parties involved, and that was a case involving the Permanent Court of Arbitration. There was an ongoing dispute regarding the South Philippine Sea or the South China Sea. It depends on whose side you're on, how you're going to phrase it. It was a dispute between China and the Philippines. And basically, a very advanced group of hackers hacked the website of the Permanent Court of Arbitration, the part that was sort of devoted to this particular dispute, so that every person that entered that part of that website would have malicious software installed that would make it easier to access their data. And that data was intended to be used in the dispute to help the Chinese side. So I think the second panel is probably going to cover that in more detail, but arbitration proceedings are a very tough situation to cover from a cybersecurity perspective, because you've got at least 3 or more actors that need to be secure, that keep exchanging a lot of sensitive information. So it's a nightmare.
And especially in dispute resolution, when in advance of the hearing you are creating an electronic bundle, exactly. You store all information on one cloud to give access to the members of the tribunal, secretary, witnesses, and so on. Jan, can I call you out and ask you what duties we have as lawyers? Because I guess they are even higher than a regular business, given our duty of confidentiality towards our client.
Sure enough, as we all know, the professional secrecy is the very core of our profession. So I would say that as a lawyers, it actually brings me to a sad conclusion that we are probably the most vulnerable business as to such kind of security breaches. Well, because this could basically compromise us as lawyers, as professionals towards our clients. Also, this could cause liability not only to the clients who might have claims because of their secrets being compromised, but also obviously we have the we have the liability under the code of conduct, professional code of conduct, and also in extreme situations, I could imagine that the prosecutor might ask questions about the level of security that's been in place in the law firm. So yeah. The conclusion was there already. We're definitely very vulnerable, and I don't think that there are many kinds of businesses that would be at risk so much as lawyers.
Any other thoughts what we can do as lawyers to avoid cybersecurity, risks which are unavoidable? Looking at you, Wojciech, because I posed the same question to you earlier about practical tips.
Thank you. Thank you. That's correct. That we probably will suffer contractually in case of a breach and cyber attack towards our clients. It's quite likely that we'll have tortious liability, but but I think it doesn't matter that much compared to our ethical harm. I mean, we should take care of the data that our clients give us, right? That's the most important. And that's ethical element, I think to some extent can be trained, and the training should start today, dear Mutis. Did you check whether your hard drives are locked? Can you make sure your hard drives are secured and your phone has enough passwords? Start with basics. Train being prepared for the world that is coming in your professional life. I'm not asking you to review the terms and conditions of the software you're using to store data in cloud and cooperate in cloud. That's what you will do when you run your law firm, to make sure where the databases are, whether they are in European Union or GDPR compliant area, and what's the level of protection that those solutions offer. You can do that when you start your law firm. But right now, start with the basics. Set one channel of communication, don't use everything, and make sure you communicate in a secure way. It's on us. It's being cautious, it's being prepared, and not believing when you receive an email from your friend asking for a confidential file or payment to a certain bank account, because it's likely phishing. I must tell you, I was for a long time giving lectures on basics of law at here at the university, at the mathematics and informatics division of the university, and students during one of the lectures showed me how easy it is to pretend that you're writing from somebody's email. They actually send an email from donald@trump.com to me. Without going to the headers of that email, you won't be able to distinguish. So be careful and train yourself. My practical tip is to train, all the time train.
Yes, if I may, Wojciech, when you started saying about ethics, I thought we'll be discussing paying ransom. Yeah, once again, I thought so. But yeah, not much to add here. I'll just say a basic cyber hygiene can make miracles. It will prevent the basic cyber threats that probably most of us has been exposed to many times. So yeah, I would agree here with Wojciech. Wojciech also mentioned before the basic cloud services, and I would agree here. I think most of the law firms today, they apply such services in their day-to-day activity, and I would obviously cloud services exposed to some other risks, but I don't think they are very important for such small organizations like ours, no matter the size of the law firm. And yes, the cloud services can provide very easily a lot of security features, easy applicable, easy manageable, way easier than it can be made on site.
Our time is running up. I hope that the audience found this panel helpful and useful. But before we finish, I just want to ask each of our speakers to provide one final takeaway point for our audience. What do you want our audience, mutis, students, but also professionals, to remember about cybersecurity risks?
I may start.
Please do.
Maybe it won't be about the cybersecurity risk, but as I noticed, most of the audience are the students. Then I would say, I think that this, let's say, the branch of law and the trends within this branch and the upcoming regulations, I think they make it an interesting idea to be part of it in your future professional life.
You're already recruiting your
I
future
am recruiting.
lawyers and
Well,
associates.
with Wojciech before. I'm sorry, I'll say it first. Well, I am recruiting, and if anyone is interested, you can just email your CV. info@gppartners.pl. Thank you.
That was a product placement.
Unauthorized,
No fishing, please.
unauthorized.
No fishing.
Wojtek, what about you?
Yeah,
What's your email?
Are you hiring?
I will join you in saying that cybersecurity, IT, and challenges created by modern technologies are fascinating. You are never sitting in one place. You're always changing your practice, thinking about new problems. On all those hackers, they are lovely. They give you opportunity to think about new factual challenges, new legal problems, cross-jurisdictional, multi-layer problems, and it's just fascinating. Don't be afraid of cybersecurity. Don't be afraid to use technology. Just stay cautious, like with everything.
Jan?
Yeah, nothing much to add, but I would definitely advise you to be aware. You have been probably already subject to a cyber attack a few times this year. We heard a phone ringing. This might have been a cyber attack, actually. So this is everyday business. So yeah, beware and be cautious.
And finally, Jakub, final word from you.
I think you should remember the topic of the event. I think it's best to think about cybersecurity. It's best not to think about cybersecurity. It's better to think about cyber resilience. Like even coming back to your example from the morning show, if they had a procedure for alternative power supplies, then the problem might have been less severe. I think that's the way the entire world is moving ahead now in the cybersecurity world. I mean, this is also a way I'd like my lawyer to think about cybersecurity, or my junior lawyer to think about cybersecurity when working with me.
I would add just 2 recommendations. Watch Killing the Mockingbird and Morning Show. Thank you very much for your Mission Impossible, exactly. Thank you very much for your patience and for voting on whether to pay the ransom or not. And thank you to our distinguished speakers. It was a pleasure. Thank you.
I promised you that you'll get a lot of food for thought. I didn't know that you will probably also get an opportunity to find a new job, but that was a very nice bonus. Now there will be a break until 3:15, and please be here on 3:15 because there will be a very interesting presentation by Agata Zwolankiewicz on the fantastic activities of the Moot Alumni Association that will be probably of your interest when you finish mooting this year. So we see you in half an hour. Yeah, a bit more, but yeah, 3:15. See you. Ladies and gentlemen, welcome back. And now, as promised, Agata Zwolankiewicz will deliver a presentation about the Mood Alumni Association and about their fantastic activities in engaging the ex-Mooties and actual Mooties, I guess, in this community and keeping this community together. I strongly recommend joining this association and following their events worldwide. Agata, the floor is yours.
Thank you, Janek. Good afternoon, everyone. Welcome after the break. I must admit it is a pleasure to act sort of as a support band before the main event, and that is the panel moderated by Professor Marcin Asłanowicz on securing disputes, ensuring confidentiality and integrity, and this panel also involves very distinguished speakers. As mentioned, my name is Agata Zwolankiewicz, and as you can see on the slide in the corner, I am a former mentee in the MAA Mentor and Mentee program. I myself was a Mootie, and I am currently coaching SWPS team. I'm also an associate with Linklaters Warsaw, Litigation, Arbitration, and Investigations Department. Members of the tribunal, today I will make 2 submissions. First, I will tell you what Mood Alumni Association is and what it does. And second, I will persuade you that it is worth it to join. I promise to keep my presentation short, as the organizers have provided a 15-minute time slot for this presentation, and I will not ask the tribunal for the time extension. Sorry, just technical difficulties. I don't know where should I point, so it changes. Oh, it changed. Sorry. Moving on to my first submission, I will now address the issue of what Mood Alumni Association is. On the slide, you can see that this is a non-governmental organization which is involved in the continued promotion of international arbitration and trade law. In other words, this is an organization for people who are out of the mood. Right now, you have submitted your written memoranda, you had some of your first pleadings, and you even attended some of the first pre-moods from what I heard. You will have fantastic time both in Vienna and Hong Kong if you're going. And once you're back, you will ask yourself a question. Is it really all over? Is the mooting career over? What am I going to do with all the free time that I now have? We like to say that once you're in the mood, you're forever in the mood. Mood is like mafia, in a good sense of the word, of course. And this is where MAA comes in. This is the organization that helps you stay connected to the mood, to the arbitration community, to really use the opportunities that you were given during your mooting journey and to use it to build an international career in arbitration. MAA was founded in 1996 during the 3rd Wiesmoot in Vienna, and as you know, now we have the twin competition in Hong Kong. And right now, correct me if I'm wrong, we're in the 31st edition. I don't see anyone waving that it's not. My math is not correct, so let's stick with 31st edition. We have over 5,000 members worldwide, and that number is still growing. Very distinguished academics and professionals are also members of the MAA. So what MAA does? It not only organizes parties in Vienna or in the Mood Bar, but I'm sure that you're familiar with that place already. It also organizes events throughout the whole year, and you may even have attended some of the workshops, some of the trainings. It holds conferences also in Vienna and in Hong Kong, and I really recommend that you join this one. It has an arbitration blog, a mentorship program, podcasts, and some networking events. It is really worth it to follow MAA on LinkedIn or on Facebook, because MAA publishes a lot of information on academic and professional opportunities. If you want to have an internship, perhaps abroad, you really should follow MAA because you may encounter some really interesting offers. And another very interesting thing that MAA does is the publication of the Vindebona Journal of International Commercial Law and Arbitration. Right now, you're working on very important, very interesting and complex legal issues, and you might as well try to put it in writing and think about publishing one of your first articles. This is something that MAA can help you do through Vindebona Journal of International Commercial Law and Arbitration. On the next slide, you can see the division of the, so to speak, core team. They have an executive board and some of the branches that are responsible for making sure that you get the best experience possible throughout your mooting journey. There's the Vindebona Journal team, media team, conferences and events team, mentor-mentee program. We also have regional representatives and the other teams you can see on the slide and also on the website with responsible individuals. And on that note, I would like to mention that the Polish arbitration community is very much involved in what MAA does. We have our very own regional representative, Dr. Maciej Durbas, who could not have joined today and who asked me to deliver this presentation. He's the coach for the Jagiellonian team, and for many, many years, he has organized many fantastic events for the Mooties. And also we have our very own Alicja Zielińska-Eisen, who's the co-chair for a conference in Vienna and who organizes many events throughout preparations for the competition, some webinars to help you draft your memoranda as well, prepare for the oral phase of the competition. And now, members of the tribunal, I would like to move to my second submission, and I will now persuade you why it is worth it to join MAA. On this slide, you can see the repetition of what MAA does, and the core team is working to provide all the best experience for you throughout the mooting journey. But when that mooting journey ends, and this is of a special relevance to me as I have some personal experience with this program, then you may become a mentee or perhaps in the future a mentor in the MAA Mentor-Mentee program. This is a program that matches students, young professionals with more experienced professionals and academics in the field of international trade law and arbitration, and this program is really unique among all the mentoring programs available out there. You get to experience one-on-one mentoring, and when you're filing your application, you can indicate whether you want to have a mentor from the same jurisdiction that you will practice in, you studied in, you intend to stay connected to, or you can choose a mentor, of course, depending on the availability, from a different jurisdiction. So perhaps if you intend to go abroad and you were wondering how to kick off your career in a different jurisdiction, you might as well ask to have a different mentor assigned to you. I myself wanted to have a mentor from Polish jurisdiction who knew legal arbitration market and who combined successfully professional and academic career, because this is something I was really interested in learning about. You can test your ideas, you can get some tips from a more senior practitioner, and it is really good to have a mentor outside of your work who has a bit of more objective view and can provide you with some objective advice. The program, as you can see, some basic information runs every year, and the call for application is in July, August each year. All the information is available on the website. You have to file an application, state your motivation, and once you're in, it is really up to you what you want to get out of this experience. This is a mentoring program tailor-made to mentees' needs, meaning that you have to put the effort and really think about what you want to get out of this mentorship. Do you want to publish an article with your mentor? Are you seeking some advice? Do you want to move abroad and do you want to talk with a practitioner from that jurisdiction? These are all the questions you must ask yourself. You must ask yourself before the first meeting with mentor. Of course, they have some general guidelines, but to make sure that you get the best out of this experience, it is up to you to tailor-make it to your needs. And with that, members of the tribunal, I will slowly proceed to the conclusion. If the slide changes. We get some of the first. Then we will conclude my submission here. I wanted to provide you with a QR code, but I'm sure that you're all tech savvy enough to find MAA website online without my help. If you want to join, follow the MAA website and you can file your application to become MAA member and after a mentee or mentor in the MAA Mentee-Mentor program. So members of the tribunal, with that I conclude my submissions. I will be around today and the following days, should you want to ask me some more personal questions. And for now, thank you for your attention and good luck tomorrow.
Well, so we'll now proceed to the second panel of today's conference. Unfortunately, we couldn't display the QR code to check if you scan every QR code you see, so we couldn't test how carefully you listened to the first panel. But now we'll delve more into arbitration-related cybersecurity issues. So we have discussed in the first panel more substantive, more technical issues, and now we will discuss the procedural part, the arbitration-related part. And the panel is entitled Securing Disputes, Ensuring Confidentiality and Integrity. And now I will pass the floor to Professor Marcin Asłanowicz, President of the Court of Arbitration Leviathan, to introduce the speakers and to moderate the panel.
Many thanks, much appreciated. Very warm welcome to the second panel. I'm very glad to introduce 4 panelists to you. I will not be introducing them right now in advance, but I'm going to be introducing each one of them before their presentation. The intention from our side is to give you a brief presentation on each one of the selected topics from each one of the panelists, but we very much encourage you and would like to ask you to raise questions, raise concerns and doubts that you may have, and ask the panelists about what they have been presenting, because I believe the discussion is the core merits of this meeting and this conference. So I will be asking some tricky questions myself in relation to each of the panelists, obviously as well, just to make their lives a little bit more difficult, but it's going to be along the way. Now, I'll start with Dominik Horodyski and ask him for the presentation of the first issue, which is the attempt to answer to the question, does arbitration have a security advantage over state courts? Now, for those of you who do not know Dr. Horodyski, I'll say a few words about him. He is a qualified dispute resolution lawyer, admitted to the Polish bar, holder of the PhD degree, unfortunately not from the University of Warsaw, but from the Jagiellonian University, which is a smaller brother of the Warsaw University, for those of you who may not be aware of that, but still we appreciate Dominic's participation in this conference. He works as the consul at the to the Republic of Poland, which is Prokuratoria Generalna Skarbu Państwa, where he represents the Republic of Poland in primarily investment arbitrations. And as well, he's the assistant professor at the law faculty of the SWPS University of Warsaw. Dominic focuses on both investment arbitration and litigation, so he's a perfect fit for the attempt to address the first concern and the first question that we have to answer during this panel. So Dominic, please, the floor is yours. Does arbitration have a security advantage over state courts?
Okay, can you hear me now? Yes, I can hear you, that you can hear me. Perfect. Good afternoon, everyone. Thank you, Marcin, for introducing my person to the audience. First, I would like to thank the organizers for inviting me to this panel and allowing me to share my views and my experiences on this extremely up-to-date topic. I feel honored. At the same time, I would like to congratulate the organizers, Professor Marcin Dziurda and Piotr Golędzinowski, who unfortunately is not present here with us, but who is watching us online, for organizing this splendid conference. Not only are these issues not only are the issues of cybersecurity a key problem of this year's Wismut case, but also they are crucial for dispute resolution in practice, for practitioners of dispute resolution. For both those reasons, I appreciate the selection of the topic and problems that are presented during the panel discussions today. I have prepared a small presentation for today just to make it easier for the audience to follow my thoughts. I was asked to tell you more, to elaborate a topic, does arbitration have a security advantage over state courts? I allowed myself to modify a little bit this question because I added cybersecurity advantage over state courts. This is because we can approach the security issues in two different levels. We can talk about physical security and we can talk about cyber security. Those are two levels of security that are present in the systems of dispute resolution, regardless whether this is state court or arbitration. So on my presentation today, I would like to focus more on cyber security, as this is the topic of today's conference and the main problem of Wismut case. However, as you will see, those dimensions of security are connected one another. So it's quite hard to distinguish them entirely. My presentation will be guided by the small plan I have prepared. First, I will discuss what are the basics, what are the basic differences between arbitration and state courts in terms of security or cyber security. Then I will present a definition what the cyber security is in relation to arbitration. Next, I will try to show you a comparison between arbitration and state courts in terms of cyber security. And I will try to, or I hope we will try to figure out whether the arbitration has indeed advantages over state courts in terms of cyber security. In conclusions, I would like to present you with some takeaway messages that came to my mind after exploring the topic and preparing this presentation. So I have listed 3 criteria that are important in terms of cyber security for arbitration and state courts. And those criteria can show that arbitration has a significant advantage at the outset over state courts. First thing is confidentiality of arbitration. Confidentiality is considered one of the main characteristics of arbitration. This is the reason why parties decide to choose arbitration over state court. And confidentiality alone can increase the cybersecurity of arbitration comparing to state courts. Then we have access to case files, and again, on this field, arbitration prevails. In arbitration, we have a strict, restricted access to case files. Only the parties are allowed to access the case files. And another trait of arbitration that we can distinguish is the confidentiality of awards. And this is, again, something that can increase the cybersecurity of the arbitration process of dispute resolution in arbitration. On the contrary, we have state courts proceedings. In state courts proceedings, the main characteristic is openness. The state courts proceedings are open to public. The public can be present during court hearings. The public can know or can be aware of the court proceedings. Of course, we have some limitations to the public hearings, but the general rule is that the public hearings are open. Then we have access to case files. Of course, at the outset, the access to the case files is granted to parties. The parties are allowed to access the case files. However, in court proceedings, we have some options that make other people access the court files. For example, the individuals other than parties can access the case files upon proving the legal interest. So this can compromise the security of the proceedings and compromise the confidentiality of the court's proceedings. In addition, the case files may be borrowed by another court, may be joined to another case, which also can impact the security of the files and security of information. And of course, the state courts' orders, awards are public. Those awards are publicly announced, and the awards of the Supreme courts, like appellate courts and the Supreme courts, are published. So we can see what the case was about. Of course, the personal data is anonymized, so we cannot detect the parties to the dispute. We cannot see entirely who was involved in the dispute, but the facts of the case are public. Those awards are published. Now, what is cybersecurity? The cybersecurity was discussed during previous panels, so I hope we know much about it. There are different definitions of cybersecurity. I have selected two definitions which are presented on the slide. One definition comes from cybersecurity protocol in international arbitration, and it says cybersecurity concerns the means employed to maintain the confidentiality, integrity, and availability of digital information, and is one aspect of information security. Another definition which we can have is the definition that I copied from the US website. Cybersecurity is the art of protecting network. Oh, it's not visible. Oh, yes, that's the, oh, thank you very much. Yeah. Okay, thank you. Sure, it will be helpful. The second definition I have provided you with is the definition coming from the US agency, saying cybersecurity is the art of protecting networks, devices, and data from... No. That's the okay. Yeah, we are here. But thank you for indication. So, and data from unauthorized access or criminal use in the practice of ensuring confidentiality, integrity, and availability of information. As you see, both those definitions have many common points, and those common... Sorry? Yeah, sure. And those common points are those I have listed here on the slide. So cybersecurity concerns confidentiality. Confidentiality means the restricted access to documents that is granted to selected group of people. Confidentiality means or relates to integrity. Integrity here means the access to unchanged documents or the documents that are original in the form, in the shape they were uploaded by the author of those documents. Then cybersecurity can relate to the availability of information. The availability of information relates to the possibility of use the information, the data at different points of time. And then we have protection of data from unauthorized access or use, and protection of users from malware, spyware, cyber viruses, or cyber attacks, or any other attempts to breach the security of data or data users. In both court proceedings and arbitral proceedings, we have the same steps that may involve issues of cybersecurity. Those steps are as follows. We have, as a first step, filing of parties' submissions with exhibits. Of course, in arbitration, we have some pre-arbitration steps, or initial steps, like conferences with the arbitral tribunal or appointment of the arbitrators, notifications, and so on. But the common step that we have both in court proceedings and arbitral proceedings are the filing of parties' submissions with exhibits. And of course, those exhibits can take different forms. We can file exhibits in paper, we can file exhibits on flash drivers, on clouds, when we are in arbitral proceedings, and so on. So different ways of uploading or presenting exhibits in those proceedings. I will talk a little bit more about it later on. Then we have conduct of the evidentiary proceedings, which can also pose some cybersecurity issues in both court proceedings and arbitral proceedings. Then we have a hearing, access to case files, and possible instances of data breach. Going through those steps, I have prepared a small table with comparison between arbitration and state courts. And I tried to compare what we can have or what we have in arbitration and what we can have or have in state courts or in court proceedings. The first main difference that came to my mind was the autonomy of parties that enables the parties to decide and introduce the desired security framework and security measures to the arbitration proceedings. This is up to the parties whether they want to introduce such measures, but in recent publications, I will show you those later on, it is strongly advised that parties at least consider implementing or introducing some cybersecurity measures. The difference between arbitration and state courts in this aspect is that the parties can decide and introduce those measures which are binding not only on the parties but also on the for the arbitrators, for the arbitral tribunal, which increases the cybersecurity for the arbitration proceedings. On the other hand, in state courts, we do not have such option. Of course, parties can introduce on their own some cybersecurity measures, but those measures in general work only for the party that introduced such measure. The security framework or the security framework can include, for example, adopting certain documents, certain protocols which are available for parties. I have listed here the ICCA NYC bar CPR cybersecurity protocol for international arbitration, or protocol for online case management in international arbitration, but we have many more. We have many more sources, many more documents that relate to cybersecurity. For example, IBA guidelines on cybersecurity and so on. So the parties have a great selection of those instruments. The party can adapt specific procedures regarding data security measures, which increase confidentiality, and the parties can increase the awareness regarding universal precautions that counter the cybersecurity threats. Then we have the specific solutions that the parties can have to strengthen the security of the proceedings. In arbitration proceedings, those solutions can be as follows. We can increase the methods of protection of our data through encryption, through data in cloud, data storage, secure share file services, VPN, FTP, double password, or we can use the systems that are provided by the arbitration institutions. Notably, one of the systems that is worth paying attention is the ICC Case Connect, which is a very useful tool to upload and download certain documents that appear in the arbitration proceedings. In courts, of course, we do not have such systems. Next, we can look at the cybersecurity issues through the lens of a hearing, through the lens of the hearing. And of course, it relates, the cybersecurity issues relate more to the oral hearings due to its characteristics. In arbitration, the parties can decide many things that increase the security. The parties can decide on choose the platform and the system to use. The parties can introduce advanced measures to enhance security, confidentiality, and integrity. The parties can have more control over the witness examination when they use hearing in arbitration than the state court online hearing. As you may know, I'm speaking here to the Polish practitioners, to Polish lawyers. We have before Polish state courts online hearings as well. There are different opinions about them, but in my opinion, the system that is used by the state courts is much less advanced than the system that we can have in arbitration when we organize oral hearing, remote hearing, online hearing. So the state courts systems do not have many functionalities, many security advantages that the systems used in arbitration have. I'm coming to the end. Now the documents, confidentiality of documents. In arbitration, parties can use online case management platforms provided by some arbitral institutions. The parties can use cloud storages. The parties can provide different methods of securing the data. The characteristic of arbitration, international arbitration at least, is that we have electronic exchange of exhibits and other submissions. which on one hand is very convenient, but on the other it poses serious threats in terms of cybersecurity and possible data breach. In arbitration, parties can also decide to lift the level of confidentiality for certain documents or increase the confidentiality requirements concerning certain documents. In state courts proceedings, we do not have such options. We have, to a certain extent, a court information portal. There are some plans I have seen today from the post published by Professor Dziurda that there are some plans to increase the functionality of this court information portal in a way that it will enable parties to submit documents, writings, pleadings through that portal. But right now, we do not have this functionality at all. This portal serves as a way for the court to publish or to transmit certain documents coming from the court, but not documents between the parties. And as a rule, in state courts, we have hard copies of pleadings, hard copies of exhibits, and so on, which can be seen from various perspectives. On one hand, as a better option than electronic exchange, but of course less convenient. My conclusions are as follows. In my opinion, after the small research I have conducted preparing to this panel, arbitration doesn't have security advantage per se. It means that as a system, arbitration is not much better than the state court when it comes to cybersecurity, but it can have significant advantage. Arbitration can be more vulnerable to security risks due to increased use of electronic exchange of submissions, documents, exhibit, online hearings. This is because cybersecurity relates more to the online transmission of documents and so on than to paper copies that are not that much vulnerable to cybersecurity, but they are more vulnerable to physical security issues, if I can put it that way. And the parties have multiple measures to reinforce the security or cybersecurity of the arbitration proceedings. If those measures are implemented and observed, the arbitration can be much more secure as a system, and the arbitration proceedings can be much more secured. Last conclusion, the security of arbitration proceedings is a matter that involves all actors of the arbitration process, so not only the parties, but also lawyers, counsel, arbitrators, and arbitral institutions are involved. All those actors should take steps to maintain the security of the proceedings, and if they do, then we have a significant level of security in arbitration proceedings. Thank you very much.
Thank you very much, Dominic, for this very interesting presentation. Now, I would like to ask you if you have any questions, clearly, and I will be excluding the panelists now, who I know that would like to comment on these, on this presentation and the other ones, but maybe somebody from the audience would like to challenge Dominic's conclusions. Most importantly, the conclusion, which was the negative answer to the question, which is that the arbitration, well, basically does not have a security advantage over state courts, which I believe might be a, kind of a tricky conclusion in this.
It was on purpose.
Yeah, I know it was. Yeah. So the question is anybody willing to comment on this or challenge? Please feel free. The purpose of this conference is to discuss the matters, not just to speak from the panelists and from the speaker side. If no, I will then ask one question myself, if I may, because the question was referring to the security advantage per se, not the cybersecurity advantage. So my question to you, Dominic, is in your view, does the fact that and you were talking about quite extensively during your presentation, but does the fact that they are in the arbitration proceedings, in a number of arbitration proceedings before various permanent arbitration courts, the electronic files are exclusive files, meaning you don't have the paper trail, you don't have the paper copies. Does this enhance somehow the security? And clearly I'm not talking about cybersecurity now, but about security in general. Do you think it matters or it not necessarily matters?
Thank you for this question. This is a very good question, I think, because it can, my first thought when I was asking this question myself was, yes, of course, arbitration has security advantages over state courts for the reasons, for example, you have presented here, because we have these electronic files and the electronic exchange of documents. So only the persons involved have access to those documents. So this is much more secure than in case when we file a submission to the state court, and then we actually, of course, we can presume that our submission will be directed to the files, but we never have 100% guarantee that our submissions will not get lost somehow. So for this reason, of course, but then when I was exploring the topic of cybersecurity, physical security, I discovered that the people who write about the approach to the security issues in international arbitration point out that the arbitral community does not use this security precautions to a greater extent. And what I mean is that when we have arbitrators or counsel who use electronic email address from a general domain, like for example, WP or ONET or any other like this, and we have heard many stories about how easy it is to access or to breach the mailbox that is not protected. For example, a mailbox that is in the WP domain. So in that case, I don't agree that per se arbitration has a security advantage, because the arbitration community does not, in general, is not very attentive to the security issues. Of course, we have some practitioners, and those are the paragons, the examples we should follow, how they act, and I can only wish that we have all arbitrators and all counsel that stick to the security rules, and this is a very good example to follow. But we have also some counsel, some lawyers, some arbitrators who are not that sensitive to security issues. And in that case, it's very easy to breach that security and access the confidential data. And of course, we have many examples concerning simple loss of flash drivers, of other storages that we use. I think anyone here on this room can recall a situation when they lost a flash driver. Right? Mm-hmm. And we can't even recall whether there was something important on that flash driver. We just don't simply remember when the flash driver is. So for these reasons, I wouldn't say that in general arbitration has security advantage, but if we are sensitive to security issues, if we pay attention, if we use measures to increase security, not only cyber security, but also physical security, then of course we can make the arbitration proceedings much more secure, both physical, in terms of physical security, and cyber security than court proceedings.
Many thanks. Very, very interesting answer. And you touched upon the issue of leakage from the mailboxes, and I think we in Poland can easily spot the world-famous Michał Dworczyk for this, but I think it is subject for a different conference probably. Okay, moving to another subject, I would like to introduce to you Ewelina Bzducha, who's going to be trying to address the second issue, meaning trying to answer the question who is responsible for the appropriate level of cybersecurity, whether it's the institution or the tribunal. Now, Evelina is certainly the best candidate for trying to address this issue because she's the member of the team of Clifford Chance, the firm that I don't have to introduce to anybody, I believe. Moreover, she's qualified both in the US, in New York, and in Poland. She graduated from the University of Miami with the LLM in International Arbitration, and she holds the diploma in International Arbitration from Columbia Law School in New York. So Evelina's practice focuses on both the investment arbitration and commercial arbitration. She has extensive international experience, so I'm pretty sure we're going to be everybody interested in hearing what she would like to tell us about the specific issue. Thank you.
Thank you. So trying to answer the question, who is responsible for the appropriate level of the cybersecurity, the institution or the tribunal, is not very easy, and the answer is not obvious. And after we finish this panel, and we will have some time for discussion, I will be actually very curious to hear from you, ladies and gentlemen, because there are simply no wrong answers to that question. But before we dive deep into this topic, I can only echo after Dominic that it is essential to remember that responsibility for cybersecurity in arbitration is always shared between the institution, the tribunal, and the parties involved. Since arbitration is a party-driven process, neither the institution nor the tribunal are going to introduce any cybersecurity protection measures without the parties' approval. This is why effective cybersecurity in arbitration is a collaborative effort. But coming back to our question, this time I decided to look at this problem from a very practical perspective. That is to kind of detach from my own expectations as a counsel, which I have when I go into the arbitration process, and to really consider who is in the position to ensure appropriate level of cybersecurity, who is equipped with the tools, and who can effectively use them. And looking from this perspective, there is a very important difference between the institutions and the tribunals. So arbitral institutions are of a permanent nature. This means that they are consistently engaged, handling a diverse range of cases with varying degrees of risk throughout the year. And it is essential for those institutions to be prepared to manage both high and low risk cases very effectively. Arbitrators, on the other hand, although very knowledgeable and may have a good understanding of cybersecurity, they are not IT specialists. Given the broad spectrum of cases they are nominated for, it's simply unrealistic to assume that an arbitrator as an individual will always have access to the most advanced technology, for example, for the protection of the state secrets. And I don't try to take responsibility from the arbitrators. The parties have the right and should expect that the arbitrators will take reasonable cybersecurity measures. However, the arbitrators, and especially those who are lawyers, are usually obliged to protect the correspondence with the parties and case-related documents under the professional codes of conduct. But in my view, the arbitral institutions are uniquely positioned to ensure that arbitration proceedings are secure and prone to cyber attacks. And why is that? Because the institutions, having this huge caseload and dealing with different cybersecurity challenges, know what to expect when it comes to specific types of sensitive data. This is why, with every registered case, it is very important that the parties involved, together with the support of the tribunal and the institution, assess the risk profile of the arbitration. Assessing the risk profile gives the participants of the arbitration an idea of what kind of security measures should be applied. Is it enough if we just exchange the exhibits through email, or maybe we need an encryption code? This is a very important decision, which obviously can generate a lot of costs for the parties, and there are different factors which should be considered in this process. And the first factor, which we should always take into account, is the nature of the information that is processed in the arbitration. So, for example, whether confidential information, including financial or accounting records, will be processed, whether any types of data that require special consideration is involved, that is, intellectual property, trade secrets, health or medical information, or the credit card payments. Another factor that should be considered are risks relating to the subject matter of the arbitration or the identity of the parties, key witnesses, and other participants. Here it is important to consider whether the matter involves a party or other participant with a history of being targeted for the cyber attacks, and whether the matter involves parties or others that handle large amounts of high-value confidential information. So, for example, the law firm, a bank, or the healthcare provider. Other factors that should be considered are the size and the value of the dispute and the consequences of the potential breach. This isn't the exhaustive list, but rather just a couple of examples that should be taken into account when assessing the risk profile of the dispute and choosing the appropriate security measures. I didn't come up with this list, sadly. There is a great document which Dominic already mentioned before, and it gives a detailed guidance on how to assess the risk profile. This is the ICCA, New York City Bar Association, and CPR Protocol on Cybersecurity in International Arbitration. The document was co-authored by independent arbitrators, by counsel, representatives of the ICCA and the CPR, and it offers a very good guidance on cybersecurity in international arbitration, so I highly recommend it to anyone interested in the topic. But coming back to our risk assessment profile, only after this has been done, the parties involved in the arbitration can make a really informed decision about the cybersecurity measures that they want to apply. So now let's turn into a little bit more practical side of our discussion. I said that arbitral institutions are responsible and uniquely positioned to ensure appropriate cybersecurity level in arbitration. But do arbitration institutions really rise to this challenge? Do they tailor the arbitration rules to ensure the cybersecurity? And in reality, are they equipped with the tools that can help them to process and protect the data? The majority of the respondents in Queen Mary International Arbitration Survey from 2018 listed security of electronic communications as an issue that should be addressed in the arbitration rules. So now, 5 years later, I reviewed a random sample of the arbitration rules to verify whether these postulates have been answered. This may come as a surprise, but only a handful of arbitration rules includes any reference to cybersecurity whatsoever. Arbitration rules of the most popular institutions like the ICC or the SIAC are silent on the topic. But the absence of mentioning cybersecurity in arbitration rules should not be interpreted as an ignorance of arbitration institutions. To the contrary, the cybersecurity requirements develop very rapidly. That's why including in the arbitration rules something more than just a general reference would require revising those rules very frequently. So instead, the majority of arbitral institutions, including the ICC, the SIAC, issued a set of cybersecurity guidelines that allow the parties to choose from the variety of cybersecurity measures which the institution offers, and also teach the parties to pay attention to risk factors that may be important from the perspective of cybersecurity. And now I will give you examples of some cybersecurity tools that arbitral institutions offer. Because we have a limited time, I will give you only 2 examples, But in my opinion, these are very interesting products which give a very good grasp about what is available from the institutional side. So starting with the SCC, since September 2019, all new arbitrations registered by the Stockholm Chamber of Commerce Arbitration Institute are administered on the SCC platform, which is a secure digital platform for communication and file sharing between the SCC, the parties, and the tribunal. So this platform simply limits the exchange of documents through emails to minimum. Each participant of the arbitration process has certain obligations when it comes to using the platform. The tribunal, for example, is responsible to ensure that particular documents are uploaded to the platforms. And these are documents like the procedural timetable, the decisions, procedural orders, and awards. Moreover, all documents and communication from the SCC to the parties are also uploaded and shared only through the platform. This may seem to you as a very basic cybersecurity tool, but in reality, it addresses multiple risks connected to exposure of confidential data, like the risk of exchanging documents by email, risk of exchanging external flash drives, the hard copies, and also ensures that only limited participants have access to the documents. Now moving on to the AAA, which is American Arbitration Association, and their very sophisticated software. So AAA offers a cybersecurity tool which is called a Case Shield. So this is a virtual desktop hosted in the cloud and developed for arbitrators and mediators to help them manage their cases. AAA states that Case Shield provides enhanced protection against phishing attempts, ransomware, issues regarding access control, password management, encryption, and so-called disaster recovery from lost, damaged, or stolen computers. This is an example of a very advanced cybersecurity tool. However, many arbitration institutions offer platforms similar to the SCC platform and platforms for secure remote arbitration hearings managed by the institution itself. So that being said, I think that we can rest assured that arbitration institutions raised to the challenge and handle cybersecurity issues very well. They are not only uniquely positioned to ensure the appropriate level of cybersecurity, but they also constantly improve their services to face the upcoming challenges and the security threats.
Many thanks, Evelina. I hope somebody will try to ask Evelina a question, a difficult one, but in order to give you a few more moments, I will ask the first question myself. I believe the answer that you gave in relation to the key question is that it's the institution rather, not the tribunal. Now, my question is, what in case of the ad hoc arbitration? Who is responsible then?
Obviously, when it comes to ad hoc arbitration, we are in a very different setup, which, to kind of defend my point as a in a first sentence, is that usually, even if we have the ad hoc arbitration, we can choose the institution that is going to kind of administer and help us with the arbitration from the administrative point of view. And it doesn't mean that in ad hoc arbitration we cannot use all the tools and software that I mentioned, because we can purchase the subscription to the software from the institution, and then it doesn't matter whether it's ad hoc arbitration or not. Multiple institutions allowed to use that software without regard to whether the case is registered or in the particular institution or not. But obviously this might not be the case, and then we are kind of left with the tribunal powers to support us with our cybersecurity issues. And in those cases, obviously, I think that arbitral tribunals also are equipped with multiple tools which can ensure cybersecurity, but this also requires the parties' support. So, for example, the tribunal may issue the confidentiality order. The tribunal may rule that there will be a special sequence, or we will use the special platforms to exchange the documents between the tribunal and between the parties, and the result will be the same as using the institution. However, I doubt that the tribunal will be in power to ensure those tools for the parties. So it is on the parties to, for example, ensure that they have the platform that is secured, that ensures that only limited participants are able to get access to the document, either by purchasing that kind of software, or we know that nowadays big law firms have softwares of this kind, so they may just use their own software and ensure that such order of the tribunal is effective and that they put as many efforts as they can to comply with the order of the tribunal.
Many thanks. I must tell you that we have not pre-agreed that I'm going to ask this question, but Evelina gave the absolutely fantastic answer, so it shows she's perfectly well prepared for the topic. Now, maybe this additional bonus 2 minutes gave you a chance to prepare another question to Evelina, and it's a good moment to ask her, please. Yes, please go ahead.
I wanted to ask what's your view on the risks concerning the proceedings, because now we moved online a little bit, but back in the day, at least in my mind, we have tackled the same issues. What's the difference between having a cyber attack and then having your suitcase full of written pleadings lost somewhere, sending it, or the post losing all the papers? So are we really entering a very different stage where we have new risks, or are they just different?
Thank you, Agata. And because you asked me this question, I will tell everyone the anecdote that you participated in. So back in the day, we used to work together, me and Agata, and we had a huge arbitration case which was abroad. I cannot give you any details other than that. And obviously, the arbitrators wanted to have a printed case file, so we had to print everything anyway, despite the fact that we didn't exchange the hard copies during the proceedings. And thank God we did not send the case file to that place on the particular, there was a particular day that we wanted to send the case file on to the country where the arbitration took place, but we couldn't for some reason, I don't remember. Instead, we sent 3 packages of office supplies of like Clifford Chance binders and stuff like that because we needed that for a hearing. And 3 days after that, it turned out that there was a strike of couriers and our packages got stuck in Hamburg forever. Like, we never retrieved those packages. The system stopped tracking them. They told us it's somewhere in Hamburg or Hanover, I don't remember. And they even didn't know. They said, it's in the magazine, like somewhere in the city. And we were asking, are we going to be able to retrieve that? And they said, no, there is a strike. The package will never reach the destination, and we don't know what happened to your package. If you want to retrieve the package, you can come to Hanover and like go to the magazine and look for the package. Obviously, we didn't do that. Clifford Chance binders are pricey, but not that much. But imagine if that would be our case file. I don't even want to think about it, so thank God it didn't happen. But I think you know the answer to your question. I think the risk is the same. Obviously, it changes because many, many more tribunals do not want the hard copies anymore, which is very good. And so we don't have that particular risk anymore. The only risk we have is of hacking the platform that the documents are stored in. But other than that, I think that this is the biggest difference post-COVID and pre-COVID. But still, there are many other tribunals which will ask you to print the case file just for the purpose of the hearing because they feel more comfortable when they can go through the hard copy during the hearing, and there is nothing you can do about that. So I don't think that this particular risk changed, maybe with the time, it will change more and more, and hopefully at some point we will get rid of the paper copies. But other than that, I think we are a little bit still in the same world.
And we did not agree on that question either.
So you see, Evelina can answer easily any question that you can hypothetically think of. Well, connected and not connected to the law, but now focusing on the cybersecurity. Anybody else? I can, allowing you another 30 minutes to consider, 30 seconds, sorry, to consider, I can tell you about my experience that it's, on the other hand, it's a little bit tricky not to exaggerate with the security, because I recently participated in the case in ISSC where the access to documents used to expire after 7 days. And actually, I was lazy enough not to, upload all the documents immediately, and then I was, like 2 weeks later, I was having some free time over the weekend, and I was thinking, okay, I'm gonna go through the file, and I, reserved like 2 hours to go through the files. I, sat in a chair, and I wanted to spend, afternoon going through the file, and it turned out that, okay, but you have no access. So actually, I had to request another access. So it's a little bit tricky, I think it's always cybersecurity is the priority and security is the priority, but sometimes it turns out it can be tough if it's overly secured. Go ahead, another question here.
Okay, do you hear me? Yeah. So what do you think about the threats that the use of artificial intelligence poses to the security of the arbitral proceedings?
Can you specify, like when you use the AI in the course of arbitration, does that pose the threat?
Yeah, I mean like usage of mechanism used to transcribe the proceedings.
Can you repeat, please?
Like usage of AI-based mechanism used to make a transcription of the proceedings.
Oh, thank you for that question. You wanted to add something? Go ahead.
Sure, I just want to say that it's an excellent idea to make whatever you enter into AI as public. Obviously, there is a solution to it, because you can buy a paid service, and when you buy a paid service, there is less likelihood of the data that you share with the service being, taken over by the provider, and that usually deals with the problem. But in terms of artificial intelligence, one thing I can tell you for sure, that whatever tools are on the market and whatever suppliers, their level of data protection culture is between very, very low and inexistent.
And if I may add, and I think it's connected with your question, an experience that I had like 2 weeks ago when a potential client approached us and asked us to represent him in a case where he actually filed a very extensive application for financing to one of the European institutions. And this European institution has, to cut the long story short, has produced the answer to the application using the AI. And actually, he was able to prove it, that it was put together through AI. Now, the complication that arose from that was that clearly it became public, because the AI uses the anything that you upload to the system. So the client said, the potential client said that well, actually, they lost 2 years of work of preparations of this innovation system, because somebody was stupid enough in one of the European institutions to upload this to the open access AI. So I'm not sure it responds directly to your question, but probably it's one of the comments that one may make in relation to the general issue of the AI, and not only arbitration, but in well, say, public proceedings per se. Any other questions? Please.
I would like to ask if you recall any case in which the parties disagreed upon the level of cybersecurity, like
was coś w tych bitach? Nie, też nie.
complicate the whole procedure.
Moich czasów. To nie.
Not in my personal experience. Usually, we have a pleasure to work with the council who agree for the same level of the cybersecurity measure. And as Martin already mentioned, we are kind of a little bit obsessed nowadays with that, and it's very hard to assess if you should go a level higher or level lower. So if they already are in the agreement that this particular case requires some level of the cybersecurity, we usually agree. So maybe I will leave the floor to other panelists if they had a situation like this, because I never experienced that personally.
I think the panelists got into the very, very lively internal discussion in the meantime, so we need to probably ask if there are any other questions from the audience to Evelina. No? Okay, before we move forward, I must say that as you might have noted, there are 4 panelists and there are 5 topics. So one of the topics remained not taken by anybody. And the idea was that I'm going to give you a few thoughts from my side. But when I watch the clock, it's almost 4:30, and I promised everybody that we're going to finish at 5 o'clock sharp. So maybe let me just give you one very brief thought that I have, or maybe 2, but I'm not going to be speaking longer than 3 minutes, I promise. The idea, the question that was part of the third topic was, what are the powers of the tribunal? Now, I wanted to share with you a few thoughts that I have from the perspective of the position that I've been holding for the last 4 years plus of the president of Leviathan Court of Arbitration. And my answer to this question would be that it is that tribunal that has all the powers that it may potentially have to run the security and to make sure that the security is properly performed in the arbitration hearings. So the institution is useless when it comes to the decisions, the ongoing decisions made by the tribunal and the tribunal members, because the tribunal is running the show. The institution can only supervise to a certain extent what's going on in the arbitration proceedings, but ultimately it's the president's role or the institution's role or the director general or the secretary general, you name it, is just to make sure that the formal requirements have been met. So I would say that tribunal is the one running the security issues and making sure that everything is properly in place. Now, having said that, I will come to the second very, very, very brief thought that I wanted to share with you. When it comes to I would say the clinch between the security and confidentiality, and at the same time an attempt to try to disclose certain information about the proceedings to the third parties. Now, the reason for which I'm referring to this issue is that I believe it remains in everybody's interest, both in the interest of the parties to the arbitration proceedings and the tribunal and the institution and the third parties, to make sure that everybody is at least, to a certain extent, is aware of what is the arbitration jurisprudence, I would say. So in order to make this happen, I believe that one has to disclose the arbitration awards. Now, by saying that, I'm not saying disclose fully with all the details, because clearly the arbitration proceeding is confidential and there is no question about it, but to disclose as wide information about the arbitration proceedings as one can disclose. The attempt that we have made in the Leviathan Court of Arbitration was to publish on our website, which is the practice that we have been doing in the last, 2 years roughly, the selected arbitration awards, anonymized, obviously, because clearly nobody would like to see that he or she or his or her entity was the party to the arbitration proceedings, but anonymized arbitration awards just to show everybody what is the line of jurisprudence of the arbitration institution, what is the approach of the arbitrators. Now, clearly, this does not have the direct link with the security issue, you may say, but on the other hand, I believe this is probably a pretty good example of a situation where you're trying to keep the balance between the security, confidentiality, and at the same time education, in a good sense of this word, the education of the public of the arbitration law issues. So only these very, very brief 3 remarks. I limited myself to 3 minutes. I hope I made it. This brings us to the next topic, which is going to be presented by Michał Jabłoński. Michał will be trying to answer the question, can the lack of adequate cybersecurity measures justify a party's refusal to produce documents or to introduce documents as evidence? Now, a brief word of introduction. Michał is the advocate, a PhD with several years of experience in handling court and administrative disputes, representing clients before courts and tribunals in all instances, including the Supreme Court, the Supreme Administrative Court, the Constitutional Tribunal, when it still existed, and the Court of Justice of European Union. Now, I can say that Michał is a fantastic litigator because I had a pleasure and honor to arbitrate against him. So it was a very good experience and a big pleasure. Michał, the floor is yours.
And who won?
We don't know yet, but Michał is certainly the winner because he was very good at the arbitration.
Thank you very much. Can you hear me? Okay. All right. Thank you very much. It's a pleasure to be here and to discuss cybersecurity issues with excellent experts. I would start saying that I think that the crucial word for my speech is the confidentiality, which is mentioned in the main topic of this conference. And when it comes to the refusing to produce documents on basis of lack of proper cybersecurity measures, I would say that it seems to be an excellent idea to refuse on such a ground or for any other reason. But the obligation to produce documents is a contractual one. It is based on the, something happened with my presentation. Sorry, I don't know what's wrong. All right, so it's a contractual one. It's on. All right, thank you. So the parties decided to bound themselves by such an obligation by introducing such an obligation to the contract directly or indirectly by referring to the rules of arbitration of certain institution. And whether we can refuse to produce documents is the matter of finding a valid reason to do so. So what kind of valid reason we can find here? It can be of course, a statutory prohibition to disclose certain data to the other persons, to other parties. But of course, it can be also a reason based on contractual provisions. So it can be an exemption to such obligation based on the for example, rules of arbitration, but I know that it's not very often still. And it can be also a a kind of sufficient cause or the justified cause to refuse to produce documents. So the cause which is interpreted in such a light, or it can be a result of the consultation of the parties during the arbitration by the tribunal. I think that the issue of cybersecurity is relevant for the confidentiality of arbitration. Of course, the confidentiality seems to be main advantage of one of the main advantages of the arbitration. However, the degrees of confidentiality are different in arbitrations. We cannot say that the full confidentiality is a rule for the arbitration. So sometimes the confidentiality is not always a result of the rules of the arbitration or the very nature of the arbitration itself, but can be derived from the statutes, can be derived from the contracts, from also from the arbitration agreements and arbitration clauses. If we have a contract with the confidentiality clause, then, and it depends what is the type of such confidentiality clause and the degree of the confidentiality, and whether it relates to the cybersecurity issues, we can rely on this, and then perhaps also in the arbitration proceedings we can make it as a valid reason to refuse to produce documents. So my thesis is that lack of confidentiality obligation should lead to unjustified character of refusal to produce documents. However, I don't think that lack of confidentiality is a real one. I think that there is always a kind of confidentiality or the certain level of confidentiality between the parties and also in the arbitration proceedings. So the question whether lack of adequate cybersecurity should lead to refusal to produce documents relates to the type of information, the degree of confidentiality obligations, which govern certain relationship. So, who is responsible for that? Of course, parties, councils, institutions, tribunal and arbitrators, and also sometimes other participants. So, if you are talking about relying on lack of cybersecurity in our refusal to produce documents, perhaps we can expect that not only the tribunal, not only the institution, but also other parties and also other participants to the proceedings preserve the sufficient level of cybersecurity. So if the cybersecurity is at stake, then also the proper cybersecurity measures implemented by other parties or other participants are important for such an assessment. What are recommendations for the parties? When we've got a contract from 20 years ago with an arbitration clause, then for sure no one thought about the cybersecurity measures then. So of course we can imply that such an obligation comes from confidentiality also, but it's not obvious. So maybe if you want to preserve the proper level of the cybersecurity also in our organization and also regarding our clients, customers, and so on, then it's a good idea to review existing contracts and the arbitration process and to analyze whether we've got the sufficient level of cybersecurity also in the future arbitrations. Maybe it's a good idea to incorporate new provisions to the contracts, also to change arbitration agreements in this regard, or to change the reference to the certain court of arbitration, because maybe we need to have a court of arbitration with better cybersecurity level. What are recommendations for institutions? For sure, to be competitive on this market, you need to have a good level of cybersecurity, so you need to provide also the parties with the good solutions, IT solutions, like mentioned here, the ICC Case Connect, for example, and also to enable parties and arbitrators to discuss, to consult matters of cyber security during the arbitration proceedings. Because, as Professor Asmanowicz said, it is always the power of the tribunal to preserve such issues in the arbitration. Here are the short examples of some, in my opinion, good practices. So, for example, the orders of the tribunal regarding the confidentiality, to protecting trade secrets and confidential information. Of course, it can also, in my opinion, regard the cybersecurity issues. We've got in ICC the ICC Case Connect. Here are some, let's say, more sophisticated measures in LCIA, which also consider the electronic information shared in the arbitration. IBA rules on taking evidences and the consultation regarding the treatment of any issues of cybersecurity and data protection. I think it's also important for this stage of consultation with the parties. All right, and that's all. Thank you very much.
Thank you very much, Michał. A very interesting presentation. I will not be asking any questions you now because we are a bit short of time, but still I encourage if anybody wants to ask anything on this issue, please do not be worried. Michał is a nice person and will answer it, I hope.
Oh, good afternoon, and to all. So my question is, we are in Brazil watching a really problematic situation with the duty of disclosure. So many awards goes to the state courts and to be cancelled. So my question is, who is responsible for the cybersecurity when the award goes to the state courts?
Well, unfortunately, if we are talking about the award which goes to the state court, we have to talk about the cybersecurity measures in the state courts, because we don't have any specific one which is, let's say, special for arbitration courts that are supervised by the common courts. So this is the same level of cybersecurity. We've got the same measures as in other cases ongoing in the state courts. So this is the question regarding the, for example, the information portal of the common courts, and it seems that still in our Polish courts we've got let's say prevail of the hard copies in the court. So we've got the different problems rather than cybersecurity in the common courts.
Thank you. Any other questions to Michał? If not, I believe it's the good time for the last but not least speaker, who is Maciej Gowroński. Maciej originally told me that 5 minutes would be sufficient for him. When I said, well, maybe a little bit longer.
And he believed that.
Yeah, maybe 5 minutes is not enough. Maybe you could, talk for 10. Then ultimately he agreed he's gonna talk for a little bit longer.
And because I thought that we would have a discussion later.
Yeah, we will. We still have 14 minutes. Before I hand over the floor to Maciej, I wanted to say a few words about him. He's currently the managing partner of the Warsaw-based law firm GP Partners. He's an IT guru, I would say. He represents clients in the wide variety of cases, both in the arbitration proceedings and proceedings before the state courts. He has authored 2 Polish legal bestsellers, which is Guide to the GDPR and the Little Book on Drafting Pleadings. So I think Maciej will be kind enough now to share his experience and to tell us how to respond to the cybersecurity incident and arbitration. And in order to allow anybody to ask me a few questions, I believe we could reach a compromise of 10 minutes for you. Please go ahead.
Hi, everyone. So eventually I have a few slides. I actually put them together more for myself in case I forget what I wanted to say, because I feel slightly ill, but I think I'm capable of going through the topic. So what happens if shit happens, yeah? So let's first think what can really happen. So the data loss as it is, if our laptop or whatever data carrier falls into a bathtub, it's not a problem because we can get our information back from, the other arbitrator or the arbitration tribunal or whatever. The problem is when you lose control over data, and it may happen in that sense that we lose control and we don't know if somebody had access to the data, or we know that somebody had access to the data. And as you see here, if an arbitrator loses her phone, hopefully she doesn't notify anybody about the fact, and we can go silent about it. But the problem is that sometimes if they are too formalistic, they may actually apply law and come back to us with the information, or even worse, go to the Data Protection Authority, which is actually the proper way of addressing the problem. However, however, it generates certain issues we are going to discuss. So we're losing a phone. We may lose a laptop as well. We may send an email to somebody else than an intended addressee. I've heard about situations when a lawyer sends something instead to another lawyer, to a journalist of the same name, and then horrible situation like a suicide because it was like civic death anyway. But anyways, from a perspective of normal communication, sending an email even with confidential information to a different addressee but known addressee is probably not as grave as other situations. And the worst thing, hackers break into our systems, and what they do, obviously no, jak to jest po angielsku? Szyfrują. Encrypt our data, and they also take over the data, and then they blackmail us that they will release this data to, well, in the dark web or whatever. And actually we are helping with such situations on a daily basis. So what happens next? Next we have reputation management, crisis management, damage control. And why do we have it? We have it because we have regulatory duties. We need to do a data breach notification. Obviously, in case of criminals, they would make us do it anyway because they would come to us. But so it's not only the law which is to be blamed for the fact that we need to undergo further humiliating situations after the data breach actually happens to us. Okay, so data breach notification were for arbitration probably the only data breach notification obligations that I'm aware about, at least in Europe. This is GDPR, General Data Protection Regulation, and there are two articles, 33, 34. 33 is about the obligation to notify Data Protection Authority, and we do it unless the risk is small. It's another word, but and Article 34, we also need to inform individuals whose data were breached, actually. Unless, provided that the risk to their data or to them because of the breach of the data is high, and it's the risk to the rights and freedoms. And it may well happen in various situations, but we will limit it to data in arbitration. And I would say that in normal circumstances, and as far as I'm aware of, personal data in arbitration files are usually not of that type that would generate considerable risks to these particular persons. Obviously, it's okay case by case, but if these are business cases and they are not very, I would say, tasty, they usually are, well, at least those which I have contact with are like typical business, no bribes, no sex, no drugs, no rock and roll either. So, so then, therefore, the risk of actually leaking out this type of information related to a particular person involved in the files probably wouldn't amount to a situation where we need to inform that person. Nevertheless, so who is who? Because it's important who has the duty to notify. We have a situation in which we have institutional arbitration. In institutional arbitration, making a long story short, an arbitration institution is a data controller. That's what I say, and it's my opinion. It's not the tribunal, in my opinion, obviously. So it's the arbitration institution that needs to notify everybody about the breach. And then the arbitrators and the personnel of the Secretariat are persons acting under the authority, well, I refer to it in the presentation, it's Article 29. But then we have ad hoc arbitration. The situation differs because we may have, well, like two things. First of all, it seems the panel is first, and only after we might have a supporting institution. So the panel, arbitral panel, let's say three of us or of them, becomes a data controller. And then a supporting institution may either become a data controller as well, because it's to a large extent depends on the decision of arbitrators and the supporting institution, or it may just become a so-called processor, so somebody acting only upon the instructions of the instructing party, in our case, an arbitral panel. From like a academic perspective, probably a relation controller to processor would be better. However, it's actually very much dependent on how you prefer to structure that relation, and there are benefits to both approaches. But then what happens in case we have a situation only arbitral panel is controller? The arbitral panel, arbitrators, are obliged to do the honors and to notify everybody about the breach. And in case we have both controllers, two controllers, then it depends where the breach happens. If the breach happens at the site, let's say, of an institution, then the institution needs to inform. And if the site, it's like something just happens to data which are in the possession of an arbitrator, then we have a problem for the arbitrator and for the arbitral panel. So who else can happen? Law firm of the arbitrator may also be involved, because sometimes the arbitrator keeps their files, they keep the files in their law firm's file system. And sometimes even if the arbitrator acts as a sole proprietorship business law firm or whatever, they may be also considered an individual separate data controller obliged to inform independently or in the first place instead of the arbitral tribunal. We may see various approaches to it. So then I need to go back to the previous slide because I mixed the slides. So what happens then, you may or may not know. To me, it's a common knowledge, so I thought it was interesting. So you have got like 72 hours to notify the Data Protection Authority. Once the Data Protection Authority is notified provisionally, because it's never fully notified at the first time, then you need to assess risks to individuals and decide whether to notify them. So you do it afterwards or in parallel, because if the risk is huge and you have a feeling like that, so you should do in parallel. And when the risk is high, for instance, if important credential data are leaked. But that's not for today. And how to notify. But the interesting thing, you may have contact details of people who are in the files, and then you might be tempted to notify these people directly. Well, hopefully you don't have these contact details. And then what you should do, the only way you can do, you inform the parties, because surprisingly there is no direct obligation to inform the parties, provided the parties actually are businesses. But from this confidentiality obligation, and also if you really want to reach out the people, the persons who are affected by the breach, then you would need to reach out to the parties. And what happens next? Then in case of a big data breach, you really have a huge reputational problem, and it's also very stressful, but after a few weeks or a few months, it just passes away, and everybody forgets. And in arbitration, it's probably even less of a problem, because it's I assume that it's not going to be a huge data set, and these data are not going to be very sensitive. So it's more like not a very happy thing, like I say here, fart in an elevator. You need to be with it, but then after some time it also will go away. And then the liability thing, I'll get back to the liability. So the question is, interestingly, who is liable for data breach which happens in arbitration? So we have exclusion of liability in arbitral procedures, and well, whether these exclusions of liability are enforceable or actually effective, maybe they are, maybe they're not. But they are for sure not effective against data subjects. So people whose data leaked out, they can sue whoever they believe is responsible. So in this particular case, we would say, let's say arbitral institution. And they may sue not only in the country of the arbitral institution, but also in their own country, as you see here on the presentation. So we have the last question and the response to it. Do we need an indemnification clause in the arbitration rules? The answer is yes, but no. Yes, formally it will help, because it would somehow shield the arbitration institution against potential claims and liability resulting from potential data breaches. But no, because why not? Because actually it's kind of like with liability. The less we speak about it, the less risk it will probably generate, because nobody will be so resourceful to actually try to sue. And the cost of suing in comparison to potential reward is going to be very, very well, the cost of suing is going to be relatively high in comparison to the damages that you may collect in such a situation. And you have also this reference to a similar situation with cyber insurance here. And what you can't see down the lower, the asterisk here is actually the source where I took it from. Thank you.
Thank you very much, Maciej. It seems that you can never trust lawyers because when they say they're going to speak for 5 minutes, they still want to speak 15. It's the last slide that we saw is a very good example of another lawyer's approach. When whatever question a lawyer is being asked, the answer is it depends, right? Now, I'll let you still, it's 5:01 now, but I'll still let you ask a few questions to Maciej. But before I do that, I want to tell you an anecdote from my personal life. When Maciej started to make his presentation and he said about sending email to wrong persons, I reminded myself of a situation that I was the hero of many, many years ago when I started my work in Clifford Chance, and I was like 22. And I received an email from the client, which I didn't like very much. So I responded, actually I thought I'm forwarding this email to my colleague, but obviously I responded to the client saying, what an idiot. And it was pretty important client of the firm. So I actually...
Who didn't do it? Hand your raise.
Maybe in a nicer words, but not in a very straightforward manner of expressing my beliefs about the intellectual level of this client. So actually, I have no idea how, but my fantastic boss at the time, who's, I believe, still in Clifford Chance, Agnieszka Janicka, managed to somehow deal with this matter. And so we did not lose the client, and ultimately I became the friend to the guy to whom I sent the email to. But this is a good example how careful you have to be, just not to make sure you don't get into trouble, referring to what Maciej was saying. But please go ahead. Any questions to Maciej? Or anybody else? This is the time. We still, I believe, have 2 minutes if the organizers and Professor Jurda are patient enough. If not, I'd like to thank very much all the panelists and all the participants. I keep my fingers crossed for those of you who are going to be participating in the moots, in the pre-moots and in the moot in Vienna. I'm sure it's going to be a success, and I'm very much looking forward to meeting you along the legal way. Many thanks to you.
And of course, thank you, Professor Asłanowicz, for great moderating. And thank you all. As our conference comes to a close, I just wanted to express our gratitude on behalf of organizers to all the sponsors, all the partners of this event, all the great speakers and moderators, and to all of you thank you for participating. And dear Mooties, all the best for this journey. Take the most out of it, and best of luck for tomorrow's oral rounds and for the main oral rounds in Vienna and in Hong Kong. Fingers crossed that everything goes smoothly for you. Thank you very much once again for being here. And, well, remember that Wismut is not only about advocacy, not only about persuasive arguments, but as Agata said, it's a great community and it's a great adventure. So, best of luck.